Please take your seats. We're ready to resume. We're back from our recess. We were in the process of our questioning of Ms. Troy. Ms. Troy, you'd still be under the same oath as we were before the break. The way we'll proceed at this point is I'm going to start on my far left and sweep across the room to my far right and then come back to the left and proceed in that fashion. I don't think we've done it that way yet. So, Delegate Fast, do you have any questions for Ms. Troy?
Yes. Thank you, Mr. Chairman. Thank you, Ms. Troy, for being here. The idea that there were no written policies regarding spending, I think that's what you testified to. And Justice Workman recommended that a written policy be promulgated, among other things, including the P cards. Is that correct? Okay. When was this request made of her?
That would have been the summer or possibly fall of 2015. It was the year that she was the Chief Justice, the last time she was the Chief Justice. So it was that's when she was the Chief Justice? Correct, yes. Okay. And if, just summarizing, I think you said that Steve Canterbury said no, or to that effect, that wasn't necessary, or what was Canterbury's response? That I didn't need to worry about developing those because we weren't going to do that. So was this where Justice Workman came directly to you, or did she present that in a conference meeting among all the justices? I can't say specifically. I know that she told me personally that she wanted policies and procedures developed related to P-card. I believe that they discussed that at an administrative conference as well, although I'm not positive because I typically don't participate in those. But she had communicated to me directly that she was going to make that request of the administrative director. It would be his responsibility to make sure that her request got completed. So if I can understand this correctly, she's the Chief Justice, and she wants a written policy on P cards, and Steve Canterbury comes to you and says, not going to do it. He let me know that she had made that request of him, and we need to worry about it. We were not going to do that. So did this communication come from Justice Workman to you, or did it come from Steve Canterbury to you? Justice Workman told me personally that she was going to make that request of the administrative director. It would be his responsibility to make sure that that happened. So she was following the hierarchy of how things were done, in the administrative office. And then subsequently, Steve Canterbury told you wasn't necessary, wasn't going to happen. That's correct. And then Justice Workman, I believe in 2017, asked me about that and wanted to know why were those policies never developed. And so I told her what had happened with Steve Canterbury, that he said, don't worry about that, we're not going to do that. And at that point, when she followed up, she was no longer Chief Justice? Correct.
And what was her response to your reply?
I think she was pretty aggravated that he had not followed through on the request that she had given to him.
And so it was from 2015 until 2017 that she followed up on that issue about creating a written policy on P cards.
She could have asked me in between, but I don't recall. I just know that specifically that issue came up again in 2017. The microphone off. She may have assumed it was deleted. I can't really say for sure. But I do know that she specifically addressed it again in 2017. And it could have been when it came up later that those didn't exist. And that could have been what prompted her to ask me why they didn't exist.
All right. So it's safe to say that during the remainder of her tenure as Chief Justice, she did not follow through to make sure that had been done with her administrative director, because obviously it wasn't done.
I can't say for sure if she asked him any more follow-up questions after that. She may have. I really can't say. And I'm not sure when she would have made that request to him. I would believe it would be in the administrative conference notes somewhere, but I don't know when she made that official request.
Was Steve Canterbury bucking her on this issue?
In my opinion, yes.
Okay. Okay. Did Justice Lawfrey implement any written policies and procedures that you're aware of regarding P cards or purchases or anything like that after he became Chief Justice?
No, he did not. We started drafting some policies and procedures, and that was under the direction of Judge Johnson, who became the administrative director in 2017. He fully supported that and believed that that was a good policy, and to have written policies, that was a good practice to do.
So Judge Johnson did start implementing written policies and procedures?
Yes, he did.
Okay. So Judge Johnson did not come on as administrative director until Justice Lawfrey became Chief Judge, right? Chief Justice.
That is correct, yes.
So Justice Lawfrey and two others terminated Steve Canterbury. They hired Gary Johnson as the administrative director, and then policies started to come about.
Yes, that's correct.
Okay. What policies? Well, I guess then the answer would be yes. That when Justice Lawfrey became Chief Justice, then policies were implemented at that point.
Yeah,
through the administrative director.
Yes, I'm sorry. I could have misunderstood your question. I think I took it to mean did he direct that to be done, and I didn't take that direction from him. I took it from Judge Johnson. So it could have been, yeah, just maybe.
And he gets his direction from the justices.
Yes, that's correct.
Okay. What policies were implemented when Judge Johnson became administrative director?
I know there was a major revision to the travel policy.
Okay.
We had in draft form a policy for P-card. Mm-hmm. We had in draft form a policy for procurement.
Okay.
Those had been submitted or were getting ready to be submitted to the court, and then other kind of fires came along the way, and those kind of got pushed to the back burner. So they never got fully implemented, but he was in the process of doing that.
Okay. And if there were communications between Judge Johnson, administrative director, and the justices, those communications could be in what kind of notes?
Likely the notes of the administrative conferences, where typically they meet monthly to discuss administrative issues. The justices and the administrative director do.
Okay. As to Exhibit 13, would you be able to turn there, please? I don't know if we have a computer operator. Let's see if I can find it myself. And if you would please turn to the third page of that exhibit, the fourth bullet point from the bottom. Counsel had asked you about that. It's something about the court's fixed asset inventory management system. Had not been updated since 2010. It says here, Mr. Canterbury had informed her, referring to you, this was intentional because he did not want others knowing what the court had period. Is that a correct statement?
That is correct to the best of my recollection, yes.
Can you elaborate on that? What do you mean he didn't want the court, he didn't want others knowing what the court had?
I mean detail, what I mean by that is details of the fixed assets. Putting items in specifically, how much did we pay for a specific chair or a particular desk or a particular sofa? That level of detail, I felt that he did not want that level of specificity in the state's fixed asset logs.
Does that strike you as non-transparent to the public?
It strikes me that way, yes. And now finance has taken on the role of making sure that all assets are recorded properly. At that time, IT entered their own assets, and the Administrative Services Division entered furniture and that type of things. But we took that under in finance last fall to make sure that everything is accurately entered in the state's accounting records, because there should be nothing hidden. It should all be transparent.
So that would have included all of the desk work, the chairs, in the justices' offices, the tables, the glass, the thick glass in Justice Davis's office, the floor in Justice Lawfrey's office. All of that would have been couched in this fixed asset column?
Yes, and it's all in there now. Yes.
Okay. And up until at least, well, when was the change made?
Fall of 2017. So we went back and started entering all of that old information.
So after Justice Lawfrey became Chief Justice, this practice of hiding the ball changed?
That is correct.
On the post-audit report, second post-audit report, Appendix E, it's near the very end of that report. That's where I think you had already testified, and I don't want to put words in your mouth, so if I say something that's not correct, tell me, but you had told Steve Canterbury that the commuting by Justice Ketchum, in your opinion, would have been a taxable fringe benefit, and Steve Canterbury told you that was none of your business. Is that correct?
That is my recollection of my conversation with Steve Canterbury, yes.
Okay. Did you specifically tell Steve Canterbury that, in your opinion as a CPA, that issue of Justice Ketchum commuting was a taxable fringe benefit?
The way I recall the conversation was, I keep seeing a state car frequently parked in Justice Ketchum's parking space. If he is using the vehicle for personal use, including commuting, that could be a taxable fringe benefit. I mean, he could have been using it only on state business. I don't know. I didn't know. And it could be that it was already on his W-2, but I felt it was important to disclose that to him.
Okay, and was this during the time that the IRS was performing its audit?
No, this would have been immediately after I was hired, within the first few months. And the way I recall that is because of where my parking space was at the time. So this would have been in the fall, early fall of 2012 that we had that conversation.
Okay, well before the IRS audit then.
Yes.
And so Steve Canterbury knew then when the IRS audit did come about that, unless he just totally forgot, he knew what you had told him that you believed that would have been a taxable fringe benefit.
Steve had already been terminated by that time. He was let go in January of 2017, and we got the first audit notice in May of 17. So he was not there at that time.
Are you aware that Steve Canterbury testified under oath that the reason the IRS concluded that no amended W-2 forms were necessary was because the IRS just didn't have the information?
I did not hear all of Steve's testimony. I did not hear that section of his testimony, no.
If that's what he testified, would that have been a truthful statement, that the IRS didn't have the information?
And what was his testimony again?
That the IRS, the reason they concluded that no amended W-2s were necessary involving the commuting issue was because they didn't have the correct information.
I really can't speak to that because I wasn't involved when they had the discussion about the vehicle, so I don't want to speculate on that.
Okay. Let me ask you this. After Justice Lawfrey became Chief Justice of the Supreme Court, were there a reduction in the overall expenditures of the court?
Yes, there were dramatic reductions.
Okay, can you give me an estimate about how much, when you say dramatic, we talking hundreds, millions?
Off the top of my head, I'm going to say at least $8 million savings.
And was that at the direction of Justice Lawfrey, or the leadership of Justice Lawfrey, or someone else?
I can't say under the direction, but under the leadership. He would have been Chief Justice during that time, yes.
And as far as the spend, we talked about, we're generically calling it a spend down, and I understand there were a lot of expenses in renovation and construction on the east wing of the Supreme Court. Is there any breakdown anywhere between what was a renovation versus what was a restoration? Because I've seen in the documents, it's sort of these terms seem to be fluctuating back and forth.
I've never seen it broken down separately, right? What was a restoration versus a renovation? No, I've never seen it that way.
Okay. Now, on these renovations / restorations, first of all, is it true that really started in 2008?
I believe that's correct based on my search of documents. I didn't come to work for the court until 2012, so I wasn't there to have kind of firsthand knowledge of that. But when I looked back through the documents, I believe that's when the work began, was in 2008.
Okay, so if someone made that statement, it would not be a lie then?
That's correct. I think the sealing invoices start, I think the sealing contract even was signed in 2008. I think that's correct.
And do you know how much, if at all, the Capitol Building Commission was involved in the renovations/restorations of the justices, well, the whole Supreme Court? I mean, we just took a tour, a lot of nice stuff. Some would call it extravagant, some may not. How much, if at all, was the Capitol Building Commission involved in those decisions to do what was done over there?
I have no knowledge of that at all. No one's ever spoken to me about that.
Okay. Do you know if Steve Canterbury was a member of the Capitol Building Commission just by virtue of his office or his position?
I don't know that it was by virtue of his position, because I don't know that Judge Johnson held the same role. I do know that Steve was a member of that, but I don't know how he became a member of it.
Okay. Now, you mentioned that earlier, you said you got the impression that justices did not know what their office renovations cost. Am I correct? And I don't want to put words in your mouth.
I believe that to be correct, because no one had ever asked me to tally up how much their offices cost. So if they knew, I don't know how they would have known, because they didn't see the invoices.
Can you expound on that? I mean, were they completely in the dark on the cost of these things? I mean, putting a inlaid floor of the state of West Virginia, or glass shells that are 4 inches thick. Is there any? Can you expound? I mean, do you believe they were completely oblivious as to the cost? Having couches reupholstered at thousands and thousands of dollars?
I really don't know, because they never spoke to me about when their offices were being renovated or restored, or whatever we want to call it. No one ever came to me to say, how much is this costing? What's the estimate on this? I was never asked for that, nor did I ever speak to them while these renovation projects were going on. It was just not something I got involved in. Okay.
Now, you saw a lot of invoices come through across your desk with all these renovations and expenses, et cetera. A lot of contractors, architects, things like that. Did you realize, and this is probably an opinion question, but maybe not, did you realize that there were any particular contractors, architects, subcontractors that were involved in any of this work that were just milking the system?
No, not that I was aware of. I wasn't really that involved in walking through the offices while these renovations were going on. I know that Steve Canterbury was very involved and met with the contractors and kind of oversaw the project, but I personally didn't go upstairs much at all during that time.
And who approved, who was the primary person to approve payment of invoices that would come in?
Most all of them have Steve Canterbury's approval on them, have his signature on them.
And do you know if he got an invoice for, say, $30,000, did he have to go get someone else's approval, or could he just sign it and it was done, paid for?
What he relayed to me was that he had full authority to sign invoices that were related to the remodeling of the offices, that he did not need additional authority for that.
Did you ever see him take let's say a $80,000 invoice and say, whoa, I need to check into did he ever go get approval, discussion on anything, or did he just sign it and give it back to you?
If he took it to the court, I wouldn't have known about that. What I can say is that I don't recall seeing any invoices signed by a justice. So if he took it to them to discuss it, he didn't get a signature on it.
And how fast of a turnaround if you gave him an invoice, or did you physically present an invoice? Here's another one that needs paid.
The contractor invoices from Nabergall always went through, or I say always, I think that's a correct statement, went through our administrative services director first. And then he would say, this amount of work has been completed. There would be a memo with that. He would send that to Steve Canterbury for Steve's signature. Then the invoice would come to finance for payment.
So you got it after Steve signed it?
That is correct, yes.
Okay, got it. And as far as Exhibit 64, that's the exhibit talking about the memo to Justice Davis about some things that had been paid by the state that she was supposed to pay for. And so I think you said that she went ahead and cut a check out of her personal funds to pay for those things?
Yes, she did.
Is that correct? How did that happen? I mean, how did things like that happen where the state paid for something that wasn't supposed to be paid for by the state?
Well, I can't really say it wasn't supposed to be paid by the state, only in that, I don't know if it's in this or not. I think if you have the large book that has all of the breakdown by offices, there's even a purchase order, like for the sofa, the $6,000 sofa. There was a purchase order done for that. So someone knew in advance that they were going to use state funds for that. Frankly, I was surprised to see this memo saying these were, the memo from Steve Canterbury to Justice Davis saying these were her personal items. Because when I looked at the documentation indicated state money was to be used to purchase those items. So I was kind of surprised that there was a miscommunication there between the two.
So you were surprised at Exhibit 64?
Yes.
Okay. Just a couple more questions. The senior status judge issue, and I heard your testimony that, you know, if a senior status judge who's drawing retirement and then gets assigned to a special assignment as a circuit judge, but then their compensation exceeded that of a sitting judge, then the practice was to convert them to a independent contractor. Am I correct?
My understanding was they were converted when it had something to do with the amount they could earn before their retirement benefits were reduced. That's what I was told, that this was an issue with the retirement board. They could only earn up to a certain amount, and otherwise their retirement benefits were reduced. And so that was the point when they were switched to independent contractor status.
Okay. Did that practice ever change?
It changed after the IRS audit because the IRS agents looked specifically at the senior status judges and found that that was not proper to pay them on a 1099 regardless of what the issue might be, that they needed to stay as W-2 employees. And so after the IRS audit, that practice ended.
And when was the IRS audit again?
It was completed, I'm going to say field work wrapped up in December of 17, but I believe their final sign-off date was sometime in January of 18.
Okay. And who implemented those changes? Was that justices, the Chief Justice, or do you know who implemented that change?
Our administrative counsel had the IRS rulings and went one by one with those rulings. Anything that the IRS found that they didn't agree with current practices, changes were made at that point based on the IRS rulings. So administrative counsel initiated the change.
Okay, and that whole idea of just on paper converting someone from an employee to an independent contractor, as a CPA, did that strike you as illegal?
It did not strike me as illegal. The Chief Justice has signed the WB-48 form. I didn't feel it was my place to question the legal opinion of a Chief Justice. If they felt it was proper to do it that way, they make legal determinations, and I follow those.
And how many Chief Justices signed this form that you know of?
Based on the documents in my office, I saw WB-48 signed by Justice Workman, Justice Davis, Justice Benjamin, and Justice Ketchum. I did not see any signed by Justice McHugh, but I was not there at any point when he would have been Chief Justice, so I wouldn't expect to find any from him.
Say Workman, Davis, Benjamin, and Ketchum.
Yes.
Not Lawfrey?
I believe there may be one by Justice Lawfrey. It wasn't in the, I just have a file in my desk, so I pulled out the ones that I had there and reviewed them. So I don't want to testify that he did not sign any. I just can testify that of the ones that I've reviewed before coming here today, I did not see any with his signature, but it could be they're just not in that file together.
You're not sure?
I'm not sure exactly.
Okay. Now, last question.
Excuse me, Delegate Fast. I'm going to move on if you'll hold your last few questions. I've heard that before.
No, it is.
All right, one more question.
You testified, Ms. Troy, that Justice Workman came straight to you on some personal issues and did not want Steve Canterbury to learn about it, and then he learned about it and he got upset at you. What were the personal issues?
It was personnel issues in the office. She was asking about specifically about some employees in finance and who was kind of pulling their weight and who, it was personnel issues. And she wanted to know specifically what my concerns were and were my concerns being addressed. And she got upset about something and felt that Steve Canterbury wasn't doing what he should have been doing, and that's when she felt that she should address it with him.
Thank you very much. Thank you, Mr. Chairman.
Delegate Foster.
My question is also about this Exhibit 64, and it involves the things that were redone. And you said you were surprised. You said you were surprised by it, and I'm trying to follow exactly what happened, because were there POs issued that said, "Hey, this is state property"? If there's a PO issued, it wouldn't get paid. Basically, it wouldn't get paid unless a PO was issued, which is basically claiming that it was court property, correct?
Yeah, yes, exactly. I mean, when I saw the purchase order, that let me know these weren't accidentally somehow paid by state money. It was intended that state money would be spent for these items.
Who would have issued that purchase order?
It's in the big book here. Let me see if I can locate it. Okay, it's in Exhibit 51. It's about 7-8 pages in. It's a purchase order and it's issued to Capital Business Interiors, and it's for the total amount $6,100 for a sofa. And Fletch Adkins, who is the Director of Administrative Services, has signed that. So to me, this is intending to use state money to purchase this. And I believe there's a memo in here from him also to Steve Canterbury. Yes, 2 pages after that. Here's a memo to Steve Canterbury from Fletcher Adkins saying a proposal has been submitted by Capital Business Interiors to provide a sofa requested for chambers. And Steve signed off on it and signed it.
Steve signed. And that's, if Mr. Canterbury signed off on it, it was intended for purposes. Where is that, for example, that sofa, where is it now?
It's in Justice Davis's chambers.
And if it's considered personal property, is she intending to take it home after she would no longer be employed at the court? Or why this, if it was for use in the court, reupholstered or redone and then designated to be paid for by Davis? I'm not understanding where that comes from. If it was to be used in the courtroom or used in her office and it was paid for by the state and then repaid, I guess I'm trying to follow where is it because it's intended to be taken with her afterwards, or what's the intent, or do you know what the intent is?
I really have no idea. I mean, all I can do is like you kind of speculate as to why these were to be her personal items.
But it was definitely something that was intended to be paid for by the state, which was signed off on Steve Canterbury.
Certainly all the documents look that way. And that's why I was very surprised to see it on this list of personal items, because he made the list of personal items, and yet he authorized the purchase with state money.
Okay.
So those two things were inconsistent to me.
All right, thank you.
Delegate Overton.
Thank you, Mr. Chairman. Thank you for being here. Was there an inventory list of who owned what versus what justices owned equipment or office furniture? Or was it just by memory that I had purchased this, so it was mine? But was there any official record or listing of or anything marked on the furniture itself?
Not that I've ever seen, no.
And there was or was not a list that indicated that this was the justice's personal versus state purchased?
No, I've never seen anything like that. So in each office or chambers, there could be a blend of personal items and state property, but I've never seen a list distinguishing one from the other, no.
You had mentioned the disagreement with Justice Workman. Did you have any interaction with other justices as well, where they were sort of bypassing the chain of command of you dealing with Steve Canterbury, not the justices themselves?
Yes, some with Justice Lawfrey as well, because I think it's probably well established that he and Steve Canterbury had issues, and so I mean, normally he would follow the chain of command and go through Steve, but sometimes he would come to me directly if he wanted something and felt like maybe he wasn't going to get the complete story that he wanted.
Was that, so you felt that was out of the chain of command, or was that appropriate, or did you feel comfortable interacting directly?
In my position, I felt like, and I still feel this way, I report to the administrative director as well as the 5 justices. So if any of them ask me for anything, I will always respond to whatever their request is. I don't have a problem answering them directly.
So you didn't feel that it had to necessarily be filtered through Steve Canterbury?
No, I mean, if a justice wants to know something, then they certainly, I think, have the right to come and ask whatever it is they want to do. or whatever it is they want, they should have the right to do that.
You had Delegate Fast mention that there were no limits on spending authority, that that Steve Canterbury would be able to himself approve spending requests for furniture and other office equipment.
That was my understanding from Steve, was that he was given kind of open authority to make these renovations happen. That was my understanding from Steve. And
not only renovations, but office equipment, furniture, that type of thing as well?
Yes, that's correct. Anything related to that, yes.
Did you feel that there was a limit on this, what Steve could approve or not approve?
I never spoke to any of the justices about that. They never questioned me, and I never questioned them, so I went with what Steve had said, and that was that he had, open authority related to the renovations with whatever they needed.
Did you feel that he had to go back to them to get any approval, or that he would be able to make all those approvals on his own?
We never really had that conversation, if there would be a need or a time that he would need to go back. So I can't really say I have an opinion or a feeling on that one way or the other.
Did they ever make requests that you felt were unethical or that you felt uncomfortable approving?
No, not at all.
Thank you. Thank you, Mr. Chairman.
Delegate Zatazalo? Delegate Pushkin.
Thank you, Mr. Chairman, and thank you for being here. A couple follow-up questions, the questions that were being asked by the gentleman from the 32nd earlier. That was the first delegate that was asking you questions. He asked about when certain policies in regards to use of state vehicles were I guess, put into writing, or when those policies were developed, because before that there wasn't an exact policy on that, as well as some other things. And he stated that was in 2017. Was that in the fall of 2017, or was it in early 18?
Well, I appreciate everybody coming. I especially appreciate Melanie being here today, and that's really kind of today's a really neat day for me, in that I think we can put to bed once and for all this tax issue that's been looming around forevermore. Today we have been able, my son and all of his companies, to now pay any and all tax obligations that were due the state of West Virginia. Now, I've told you for months and months, I've told you that any obligation whatsoever I wouldn't walk away from. And I told you that they would be paid. The one thing that I pride myself in more than anything is telling the truth. And we've done it again. Now, I'd like our secretary and our deputy secretary to talk to you just a second, and then I'm going to talk to you some more, and then I want the DEP people to talk to you as well.
Thank you, Gov. It's on. Is it on? Okay, thank you. For those of you that don't know me, of course, I'm Dave Hardy, the Secretary of Revenue, and to my left is Alan Prunty. Alan is the Deputy Secretary of Revenue and General Counsel for the Department of Revenue, and of course, tax falls under the umbrella of the Department of Revenue. So I'm pleased to announce that I was informed by our Deputy Tax Commissioner today, and Mr. Prunty, as General Counsel of the Department of Revenue, that all taxes owed by the companies operated by J. Justice have been fully resolved to the satisfaction of the State Tax Commissioner. Thank you.
I'll clap too.
We have verified receipt by wire transfer today of all funds owed, and our tax commissioner informed me, our deputy tax commissioner, at about 1:30 p.m. that we have received all the funds. As a result, as we speak, our tax officials are working very hard to remove all the assessments across our counties involving the companies at issue, and we expect to have those liens removed no later than 48 hours from now. Now, there could be a variation here and there because we have to send them to each county clerk for removal. So on behalf of the State Tax Department, I'm allowed to say as Secretary of Revenue that we're very pleased that these matters have been resolved, and the State Tax Department is completely and totally satisfied with the resolution of all these matters. And at this point, I'm going to turn it over to Alan Prunty, because I asked Alan in April of 2017 if he would serve as the liaison between the Department of Revenue and State Tax Department as we try to work through and resolve these problems or these issues.
Thank you, David. Liaison might not be the correct word, because once Dave gave me this assignment, he told me that he didn't want to hear any details unless and until the matter was resolved and I could tell him it was resolved. And that's the way we handled it. I essentially served as a facilitator between the taxpayer, which were the companies operated by J. Justice, and the tax department. And there were some issues to be resolved. The Russians left a bit of a mess behind. But I can say that the only people in the state government that I ever discussed this matter with prior to today was Dave giving me the assignment, and the people with the tax department as we worked through these issues with J. Justice and his attorneys. I can say without any qualification that J. Justice and his attorneys and some of the executives of his committee were totally cooperative, completely transparent, and it just took a while to work through all of this because it's a complicated situation. And in addition to the state taxes, you got to realize we weren't involved in this, but there were significant real and personal property liability that was left behind by, not much has been said about that by the Russians, and that's been, as I understand, resolved as well. So I just expressed my appreciation to the fact that I was given the freedom to try to work these folks together, resolve the issues that were there. Everybody worked together, and I think it's a great day to say that we can put this to bed.
Let me jump back in now, and I want to tell you a story that I've wanted to tell you for a long, long, long time. And that's just this, is one thing I guess that we ought to, and Dave mentioned it, but along the way, I never spoke one word to either one of these people. In fact, I told Alan just a second ago, if Alan would have been standing outside, I wouldn't have had any idea who he even was. But the story, the other thing is, don't run out of here in the next 10 minutes and try to see, call some county and see if the lien has been lifted because they just told you that it's going to take 48 hours or maybe even a little more to make sure that they get all the liens released. Now, I want to go back to this and tell you just the story. I told you this a bunch of times, but when things got really, really, really tough, company after company took bankruptcy. To be perfectly honest, there's some companies within the empire that we had way before I became governor that would have been the smart thing to have done, because we could have saved ourselves hundreds of millions of dollars by just doing that. I've told you that before, and that just kind of just sails right by everybody like, well, okay, what's next? Well, the reason we didn't do that is just like I said, I don't believe in that. There would have been banks hurt. There would have been vendors hurt. There would have been all kinds of people that would have been really hurt. I don't do that. So what do? I just keep working. Now, along the way, in addition to that, along came a 1,000-year flood. Now that made things even more difficult, to say the very least. With that 1,000-year flood comes insurance companies that owe the Greenbrier nearly $70 million that's not been paid. So it stretches even more. But here's the story that I wanted to tell you forever, and that's this, is I really do believe in West Virginia. I always have. Way before I ran for governor, but I always have. And I believe in our coal miners, and I believe in coal and the opportunity for coal within our state. And so, this story that I'm getting ready to tell you parallels almost exactly what happened with the Greenbrier. You had a company, a Russian company, that bought our company. They were at the top of the world, owned companies all over the world, steel making and absolute, all kinds of different companies. Now, the whole market collapsed and things went really south. Now, along the way, that happened. We sold to the Russians, I think, in 2009. May have even been 2008, late 2000. No, I think 2009. Now, and then along the way, in 2012, things started to get really tough, and they started laying people off. And in 2013, for all practical purposes, things got shut down. Well, then in 2014, through that period, there was people that came to me and said, would you be interested in buying Bluestone back? And I said, you have to be out of your mind. There's no chance. What in the world does anybody need another coal company today? We had all the coal companies that we could have possibly wanted, and then and really would have been glad to have gotten rid of all kinds of them. And we were fighting that battle. And then they came to me and basically said this, and this is the story that I want you to really hear. The Russian company owed me $166 million on the 5th anniversary of our transaction. That was calculated on a drilling program in which we together shared the cost and drilled properties on the Bluestone properties, and for every ton of coal we proved that was not in the original sale, they would have paid $2.76 a ton. And that amount of monies was $166 million. Now, they were leaving. That is the most important statement that I could say. They were leaving West Virginia. Think about what was getting ready to happen. Here's what was happening. First of all, it was in 2015 now. The counties of McDowell and Wyoming County were owed 2014 property taxes of $2.2 million roughly in each county, each of those two counties. That had never seen a dime. Now, in addition to that, at the time in February, 2 months after that, they were owed a comparable amount again. That had never seen a dime. What would have happened to a $102 million liability to the UMWA pensioners in the pension fund that was owed at that time? That had never seen a dime. Now, in addition to that, there was reclamation beyond belief that had to be done and would normally be done in a mining process, but it was going to be left. And our state and these people over here Harold, and Austin will tell you this in a minute, our state would have been in a real mess. Now, this is nothing but the Greenbrier take two. And what did I do? I said, okay, we'll take Bluestone back. And we did. And then the next thing I did is I borrowed $56 million and thinking, well, surely that'll cover everything. In the deal, I gave up my $166 million that they owed me. I gave it up. Now, why would you do that? Why would you do all this? Now, the part that you know of this story that I've wanted to tell so much is just this. Those men of the UMWA, a lot of those men were the men my dad hired. And that means something to me. To leave our state in the situation that it would have been left in means something to me. Those counties to where I have grown up in with my grandparents and everything else means something to me. Now, we can say whatever we want, but in addition to that, I believed coal would come back. You see, I believed in what I told you in the primary, that severance taxes would rise and coal would come back. So in February of 2015, we could have cleansed this. You see, the way a lot of other companies did. How did they do it? Here's what they did. They took bankruptcy, then all these obligations, whether it be vendors or whether it be taxes or whether it be the UMWA pension or whatever, they just cleansed it away and started anew. You see, I didn't believe in that. And it made it tough. It made it beyond tough. Now, it has stretched our companies beyond belief to overcome situations, this situation right here. We paid the 2014 taxes for the Russians and the 2015 taxes for the Russians, and Wyoming and McDowell County got $2.2 million each for 14, and I think the number really is $1.9 million each in 2015 that I had nothing to do with. I had nothing whatsoever to do with. Now, along the way, then what did we do? We started plotting the course to come back and build it back. And today, we're on the way. We've got 400, right at 400 people working there. Now, that includes probably an estimate from my end of about 150 people that are working at the Coal Mountain operation that we sold out of Bluestone after we got it back from the Russians. So we continue to build it. Jay continues to build it. But the other thing that you may find difficult to think of is just this, is why in the world would Justice have bought the Greenbrier? Because he believed in it. He believed in the fact that it was our treasure in our state. This, honestly, was my dad. In doing so, you inherit real obligations and real problems in a coal market that was just so bad it was off the chart. No bankruptcies, no cleansing. Along the way, you'd walk the streets and somebody'd yell at you, why don't you pay your taxes? It was tough because I knew already that I had paid Russian taxes. Not my taxes, Russian taxes. It was tough. You know, there were $30 million of vendors that were owed by the Russians some that we had no idea if it was real or not real. You know, there was a court case that came along to where there was a notification sent from Judge Berger, Judge Berger's office to one of the Russians. We never ever got any kind of notice at all, but yet we were hung out to dry because we didn't appear at a certain time. We were penalized because we didn't appear because of something that the Russians did. Now, I can't be more proud of the end of the story of the Greenbrier, and I can't be more proud of the end of the story today of what's happened with Bluestone, what's happened with the taxes. It's been awful to take the errors, whether the errors come from the press or whether the errors come from whomever. It's been no fun. And at some point in time, one of your questions today may very well be, yeah, but what about Kentucky or what about Virginia? And I think if you'll just bide your time and wait, you'll see the exact outcome there as well. You'll see companies that we took over that were absolute DOA. You'll see the Addingtons or the Swishers or National Coal or Jerry Wharton at A&G. Every last one of them, you'll see them right on the brink of bankruptcy and or bankrupt. You'll see situations in those areas to where the state allowed reclamation to be undone for 25 years. 25 years. And then all of a sudden you'll see Jim come in and they'll say, aha, the billionaire's here. We want you to fix it today. You know, you'll find, if you dig deep enough in every hole, you'll find the same outcome. The outcome is always the same. I especially, with all my soul, love West Virginia and want goodness for our state. Now let me see if I've scribbled these things down here real quick, and let me make sure that I'm not last thing I wrote was this sentence. You see, all this happened before I became your governor that I'm talking to you now about primarily. And I wrote, I believed in West Virginia before I became your governor, and now I believe in West Virginia exactly the same, if not more. This is a great state with great people, and we're doing really good stuff. And you can, and I don't want in any way for this to be political, but you can step away from this and you can see if you look deep enough where this is coming from, what party is leading us in this state. Now, I'll turn over to our DEP people, and they can talk to you just a little bit about what would have happened if the Russians had left.
Thank you. I'm Austin Caperton, the Secretary of the Department of Environmental Protection. My first comments are not in my official capacity. They are in my official capacity as a friend of Jim. We grew up in the same town, generally speaking, belong to the same groups, organizations, country clubs, etc. I think it's time everybody stopped throwing stones. Everything that he has said that he would do, he has done. He said he would buy the Greenbrier and make it great again. You see the casino, the chapel, the tennis facility, a world-class golf tournament, and a world-class golf course. Totally turned around the image of the Greenboro Hotel and what it's meant to our state. On the, pardon me, on the mining side, he said, give me time and I'll get everything fixed, and he did. Everything he said, my friend said he would do as governor, he's gotten done so far. So from a personal standpoint, it hurts me to see the stones being thrown and continue to be thrown. I guess if you're crazy enough to get that job, that you're going to have a few people throw stones always, but I think it's unwarranted. From the official standpoint of the DEP and our role, this is Harold Ward, one of my two deputies, who is also the director of our mining program. We have experienced mining bankruptcies in West Virginia, where the state has to go and take control of operations and figure out how to reclaim those operations with the money that's left over from bonds. It's not a good sight. It's not a pretty sight. It can be uncomfortable, difficult, and we know this because we have inherited the aftermath. When the governor, approximately the time the governor took back the Meshel properties, 70% of the companies operating in West Virginia were in bankruptcy. I'm sorry, 70% of the permits that we held were held by companies in bankruptcy. Through Harold's good work and the work of others in our agency, we were able to avoid most of those situations. But for someone like the governor to step in and earn his way out of the problem is almost unheard of. Time has proved that the governor's plan for the operations in the coal industry worked to the benefit of West Virginia. Had he not stepped in, special reclamation, the fund that we use to administer permits that we've had to take back over, would have been stressed and possibly broken. The bonding companies that provide bonding for our operations probably could not have sustained the losses they would have sustained. We wouldn't have bonding companies willing to offer bonds in West Virginia any longer. Jobs would have gone down the tubes. Support businesses would have gone down the tubes. Counties would have gone down the tubes. So by all measures, the governor's efforts working alongside the DEP to stay within the laws and regulations have proved very beneficial to the state of West Virginia. Thank you, Governor and friend. Harold, do you have anything you'd like to add?
No, sir. Pretty much sums it up.
Well, let me summarize this, and let me say this. I'd like to take a bunch of credit for this, but my credit stopped when I became your governor. You know, my son's done a good job here, and we've done what we said we'd do. We paid a lot of stuff we should have never paid, and I'm not going to avoid this, but really and truly, at the end of the day, a lot of those that are casting stones, whether they have bitter feelings about me switching parties or not, the Republicans are leading us. They really are. And we're getting stuff done, and it's good stuff, and this state's on the move. And so I think this is a wonderful day from my standpoint that my son was able to, and it's been a struggle. Let me tell you something, my friend. Trying to keep the Greenbrier's doors open when the insurance company doesn't pay you, and trying to pay obligations that you know that you have and you're not going to walk away from at the tax department, and trying to do everything that has been done here, whether it was fair or unfair, whether the Russians should have paid it and they didn't. I don't care what anybody says, it was tough, really tough. And so I really have got to brag on my son and my daughter and the great work that they're doing in my absence, and today's a good day for me. So you're welcome to ask anything you want to ask. I do have an engagement I got to get to pretty soon, but I can answer, I think, for a while.
Yeah, this question has nothing to do with what you just talked about, but there was a press release put out by your office this morning. It said that you were looking for a replacement for pending vacancy on the Supreme Court. Is that talking about the Ketchum vacancy?
Yes, sir. Yes, sir.
Governor, I have 2 questions of clarification. There were reports out that you would owe, or your businesses had owed $15 million more than in 6 states. To clarify, this is just West Virginia taxes?
This is West Virginia taxes. Yes, sir. And I think what you'll see is you'll see the same process going through. May still take a little while, but you'll see the same process of cleanup in other states as well.
And another clarification here, that figure included penalties and fines to the company. When we're talking about taxes here, does that include penalties and fines owed to West Virginia?
You know me, I'm going to always tell you exactly the truth and what I know. These people worked all the minutiae out with my son. I didn't participate, never participated 1 second and everything. So everything that I know in me, every single thing is paid.
So I guess that might be a better question for you then. Does this announcement include penalties and fines owed to West Virginia, and what was the total amount owed and then paid?
I'm not at liberty to say the total amount or give you specific details because state code prohibits me from doing that. But I can say that it resolves all outstanding issues with the state of West Virginia, and that would include issues involving penalties and fines.
And I think you can tell them that it was audited as well and everything.
It was vetted, reviewed, and all parties have agreed to the appropriate amounts.
But since we don't talk about state taxes, are there any county level taxes that are out there?
No, there's not. All the counties have been paid. All the states have been paid. It's a good day. Good day. And going forward, yes, sir.
I'm not sure I understood the reason for not being able to say the total amount. Is there anyone who can tell us the total amount? It seems to be in the public realm.
The state code, pursuant to West Virginia Code, Mark Morton, the General Counsel of State Tax Department, has instructed me in writing, and it is clear in state code, that we as state officials are not allowed to discuss confidential taxpayer information. So we as state officials are not at liberty to discuss that. We'd be clearly violating state code if we did.
But the governor is at liberty to disclose that if he wishes.
And
Yeah. Excuse me.
no, go ahead. No.
Well, if I could pick up on that. The reason why I backed away from the term liaison when Secretary Hardy introduced me is because the first instruction he gave me was stay independent. I don't want to know what's going on. This is not political. Just see if you can facilitate a resolution, which is what I did. So I didn't really feel like I was acting as a liaison. But, you know, there's a lot of public records out there. The real and personal property taxes, you know, are a public record. And the liens that have been filed and unfairly used to say, well, no taxes are being paid. We all didn't know what was going on behind the scenes. There were people working very hard. There was an audit. There was a lot of documents. And as I said, the Russians left a mess. And it took a while for the tax department and the taxpayer, Jay Justice and his companies, to work these matters out and to get them resolved. All liens are going to be released, and everything that's owed will be paid as has been agreed to between the parties. As far as the confidentiality, the state code is very clear that these kinds of issues on state taxes, not real and personal property taxes that you can go to the courthouse and look up, but on state taxes, they are confidential except to the extent that the liens have been filed. The governor has not been involved and is not the taxpayer. The taxpayer is the companies and the Jay Justice who's running the companies along with his executives. So they're the taxpayers, the tax department. Those are the two parties. There's confidentiality exists. It's the same thing as if it was the IRS. And so I hope that may shed some light on and provide you some information in response to your question.
Well, and I guess without getting into the specifics, was this a negotiated price or was this a full payment of things owed as opposed to say, well, we're going to call it good. We have this total price paid for these things. Was it a full payment of the things owed, or was it a negotiated price between the tax department and businesses?
Well, as I said, you have to understand, the governor's companies they were the governor's companies before he became governor, and the companies that are run by his son and his daughter paid taxes that were incurred by the Russians. So I'm not, it depends on how you want to define owed, but there were substantial liability that was incurred by the Russians that has been paid by the justice companies.
Am I correct that none of these companies are in a blind trust, therefore the governor still has an ownership interest?
I can't speak to that. All I can tell you is that no one from state government, from the day Secretary Hardy gave me this assignment until the last few days after a settlement was in place, no one spoke with me about this matter except for the people with the state tax department.
And I can tell you, I can even add this, is I don't know what the amount is, even at this moment. I know it's millions of dollars, you know, and I know from probably my feelings that there's been dollars paid that someone else owed, and that's about all I know.
Well, in an effort towards transparency, since it's not a blind trust, would you be able to get that figure of what was owed and what was paid and get it to us?
I could. I guess that's possible that I could and everything, but I think that's a question you really need to ask my son as to whether or not that he would want to do that, because no matter what comes to you, I think what some of you are going to do is do this. It's in a situation to where I have already described to you taxes that were absolutely owed by the Russians that we paid, okay? And I have told you that these people have conducted their work, and in any kind of work, there's going to be disputes, where one party doesn't think they owe something, another party does think they owe it and everything, and they work things out. And I'm sure that there was some give and take that were, as they went through whatever they were doing. But I can tell you this, that the thing that is always troublesome is someone is looking for a tidbit of something on the negative side. And that's all we want to write or do. Now, I am referring only to one organization, and that's the Charleston Gazette. Everyone else, you do your job and you do it well, and I want to brag on you. I want to tell you that if I deserve to be beat on, I deserve to be beat on. I'm fine with that. Just to tell you a perfect example of that is there was an article that came out that we owed some. I didn't even read the article, but there was an article that came out in regard to the PSC in which we owed $100,000 or whatever. And to be perfectly honest, it was right. It was exactly right. And that, I've always told you, if I'm in the wrong, I'm in the wrong. But to just look for something in this story that could possibly be construed wrong would be just like Clark Griswold standing in front of his house after he finally got his lights on. And his dad turned and said, "Clark, on that 8th row up there, there's 2 of those lights not working." And he said, "Thanks a lot, Dad." Now, that doesn't seem like a bad thing. But now let me just go one step further. When all we write and all we look for is bad, you know what it does? It drives people away. It gets people to not come here. When every day you pick up and all you do is read the doom and gloom chronicle, it drives people away. Now, we have to stop that. We've got to report the bad when the bad's the bad. But we better start reporting the good when the good's good. Because we want people to come here We want people to celebrate how great this state is. And we want to be happy. That's all there is to it. I got to run. I don't see any other questions. Thank y'all.
Knew that because she'd used a different architectural firm, and to leave them in there because they were for her office.
Did you disclose it to him in that way that you find this to be misleading?
I don't know that I said it was misleading, but I said that I wanted to remove those so that each office was treated consistently.
Can you give me kind of a detailed explanation of how he did that? Because I think there's a big difference between what you state in this letter, that I accidentally provided something that didn't have that, and the Chief Justice of the Supreme Court of West Virginia telling you to take information or leave information out. Do you see the big difference that I see there?
I'm having a little bit of trouble hearing.
I'm sorry. I see a big difference between the way you stated in the letter here as saying I accidentally provided it without that information, and the statement that we've heard you say today that Justice Lawfrey told you not to put it in there. That's two very different stories to me, and I find a big difference there. That's what I'm trying to get explanation of how that happened and how he communicated that to you and what he said.
I'm not, are you referring to a letter from me?
I believe this is from Sue Racer Troy to Barbara Allen on July 30th, 2018. After the binder was given to Kenny Bass, additional invoices related to these office renovations have been located.
Okay, I know what you're talking about.
Do you understand what I mean? I find it different. A comment that you put in the letter is very different than Justice Lawfrey telling you not to put it in the comparison that you provided to Kenny Bass.
Yeah, I'm actually dealing with two separate issues there. My letter to Barbara Allen this binder was put together, and it was never meant to be an audited final, full accounting of the costs. I knew that we would continue to find additional items related to the offices. And so rather than altering the binder, knowing that it had gone out once and there were subsequent FOIAs for it, I left it intact, and additional items I found I kept totally separate. And so that's when I sent that memo to Barbara Allen the other day. I'm telling her these are the items I found subsequent to the production of the book. When the book was given to Kenny Bass, I made a disclosure that the ceiling architectural fees were missing from Justice Benjamin, Justice Workman, Justice Ketchum, and Justice Lawfrey's office.
So these are different fees that we're talking about in the letter.
Yes, that's correct.
But you made the same discovery of the design fees and those kind of things and provided that to Justice Lawfrey, and he told you to continue to leave them out.
I spoke to him about that. He said leave them in there because they are for her office.
And not to include the fees to his office and other justices.
I couldn't include the fees because we didn't have enough information for me to make any type of allocation of those fees.
Okay, thank you.
Delegate Flashhour.
Thank you, Mr. Chairman, and thank you for being here today. I wanted to, did you ever come to any conclusion about the differences in the costs between the different offices for the architecture charges, or is that something you're still trying to break down?
The court has requested the information from Silling. To date, we don't have any breakdown from Silling.
Okay. What can you remember, or to the best of your recollection, what was the amount in Justice Davis's office that had to do with architectural services?
I believe it was around $30,000.
Okay, so it wasn't a large portion of those renovation costs.
Right, as a percentage of the total renovation, it would not have been a large amount. No.
Okay, and do you know, you just don't have any idea what the charges were for the other 4 or 5 offices that were included in a different bill?
I can see the total, but
what was the total?
It was 300 and They broke it down into, just says justices' chambers, but it doesn't say which chamber.
Okay. It was over $300,000?
Yes.
And that was, remind me again, you've said it 3 times, but that was for Ketchum,
Benjamin, Workman, and Lawfrey's offices.
And Walker? Or Lawfrey?
No.
Okay.
Right,
thank you. You said that you're an at-will employee. Did you ever get the impression that Lawfrey expected loyalty from you? Is that something, you said there was an atmosphere of fear because people were losing their jobs around you. Did you have an expectation of loyalty, did you have an understanding that he expected you to be loyal?
I think that each of the justices expect us to do our job and be loyal to the court, and
did you feel any differently when he became Chief Justice? That there was an expectation you should be loyal to him over and above any of the other justices?
I didn't feel that way because I've always felt that the 5 are equal, regardless of who the chief is. To me, all 5 are equal.
Okay. You said that, I'm a little bit confused. We know, you talked about the fixed asset inventory, that it was kept in the past under the FIMS system. And I think you said it was kept until 2010. Is that right?
That's what the FIMS records indicate. I couldn't find anything being added after 2010.
And that would have, and I was a little confused about whether you said that was Mr. Fletch Adkins or whether that was Mr. Probst who was responsible for doing that.
When I came to work for the court, I was told administrative services did that. Fletch Adkins took care of that.
Who told you that, if you can recall?
I think Fletch himself told me, or Mike Probst may have told me. There was a division on kind of who was doing what.
Okay.
And I do know that I talked to Fletch about the fixed assets, and so I knew that he did that.
So was Mr. Probst on for a while? I don't think. Did he stay for a while after you started?
We trained for 1 month together.
For 1 month, okay. So do you recall any conversation with him about the keeping track of fixed assets, that was his responsibility?
But Mike Probst did not do that. By the time that unless he did it at some point in the past, and then it may have transferred to Fletch Adkins, but when I was training with Mike Probst, finance was not responsible for adding the fixed assets into the system.
So he didn't say that was part of his job?
No, absolutely not.
Okay. Did you ever, with the work that you were doing, let me go back to Exhibit 69, one of the first ones we talked about today, and let's just look at the first page of that. What I have written down here, you talked about item E under operating expenses. And that's building repairs and improvements, just on the first page. And you said that was where the ceiling invoices would be, right?
That's where they would be allocated. Now, this only is for 2 months of the fiscal year, so this would have only been items paid in July and August of 2012. This is just for that specific time frame.
Okay, would that have included anything else for circuit courts or magistrate courts that were repaired or improved?
Yes, that would include everything for all.
So it's just a part of a larger amount,
yes.
Possibly. We don't know what was done this doesn't indicate exactly where those repairs were made.
That is correct, yes.
Okay. Going back to that letter that Justice Davis or Mr. Canterbury wrote in 2016, he wrote it to Ms. Davis, but it doesn't, or Justice Davis, it doesn't appear to be signed. This was March 14th, 2016, that was done. And this was long before any investigations, right?
Yes.
And so was it like this 1970 coffee table? Was that something that was purchased in 1970 or bought later? Do you know, if you know?
I think the coffee table I'm not sure about. I know the chairs and the sofa were purchased later, I guess, like as vintage items. But the coffee table, I'm not sure about that one.
What about the lamps? Because there's a big list of things here.
I found no evidence that those were ever purchased with state funds, so I don't have any.
So the only two things that you think might have, do you think there is a possibility there was just confusion here about who paid for what? That was what you saw.
I guess I can't really say, but I can say, I can't say what they thought, but I can relay that Justice Davis seemed surprised when I talked to her that state money had been spent for those items.
And that's the only two things on this whole list where there was a discrepancy.
I think there was the sofa, the two chairs, and I think some work on the coffee table. I think they had been sent out for some kind of repair work, and that had been put on a state P card, I believe. So we identified the items that were in question.
And would that have been before or after 2016?
I'd have to look it up here in her section. The sofa was purchased in 2013 with state money. It says correct the finish on the stainless steel coffee table base. It was sent out for some kind of repair work, and that was in 2013. The shipping charge on the chairs was 2013. And the work to reupholster 2 lounge chairs purchased at auction was in 2014. So this money
Which ones are the lounge chairs? Is that the arms chairs or?
The Milo Hogman, I think is the name, armchairs.
Oh, okay. So those are the lounge chairs / armchairs.
Right.
So that was the shipping for them.
Yeah.
So there are these 3 invoices. Is there anything else on that list that you have to indicate that is state property or not state property?
No, just those items: the sofa, the armchairs, and the repair work done to the coffee table.
Okay, those 3. Okay.
Yeah, I couldn't find where the coffee table was purchased with state funds, so I assume it wasn't because I couldn't find any evidence otherwise.
Okay. And then would you do I think you talked about doing invoices for contractors. Did you have anything to do, or did it ever cross your desk, invoices relating to Software Systems, Inc. that was involved in the UJA work?
I've seen those invoices. I don't know that I've personally processed any of them, but I'm familiar with the company.
Would they have go through your office, the finance division?
Yes, they would have come through finance for payment, yes.
I have information that they have an outstanding debt owed to them that they believe is owed to them for over $200,000 during this time when there were a lot of other expenses that were paid for. Do you know anything about that, why they weren't paid?
No, I have no idea. I've heard of that, and I've heard of some litigation, but I don't know any of the details of it, no.
Okay, thank you. Thank you, Mr. Chairman.
Ms. Troy, I have a series of questions regarding a couple different topics. The first one deals with this 1099 issue. So typically when an employee becomes an independent contractor, and I think you confirmed this, the withholding of payroll taxes ceases, which to me means that the employer is not only not holding any out, the employer is not paying the employer's share of Social Security, for instance, or unemployment taxes. Is that based on your knowledge as a CPA, is that correct?
Yes, that is correct.
Okay, so when these justices, when these senior status judges converted from a W-2 to a 1099, then the responsibility for withholding their own taxes for personal income taxes shifts to them, correct?
Yes, that is correct.
My understanding is that there's a wage base, and so if you are earning above the wage base, you may not have any additional tax if you get income that exceeds that Social Security wage base. That is correct, is it not?
Yes, that's right. There's a cap on Social Security and how much a person, once they earn more than a certain amount, right, that stops.
So if by chance the threshold, and from 2011, I believe, until current, the sitting circuit judges were earning $126,000. So for purposes of my example, if the total amount they drew from retirement and W-2s and 1099s did not exceed that amount, or did not exceed the wage base, then they wouldn't have had to pay any additional Social Security taxes, correct? Let me rephrase that, because I've even confused myself with that one. Okay. Let's suppose that the amount that the person received from W-2s in retirement was $100,000, and the wage base is $110,000, and then they shift to a 1099. Anything is under that $10,000, they would be responsible for Social Security tax, but over and above that, they would not. Is that fair?
I think that's correct. I'm just trying to go through all that tax law in my head.
Well, let me ask a different question. There's no limit on the Medicaid or Medicare tax, is there?
I think that's correct. I think it's just the other portion of it.
If we shifted from a W-2 to a 1099, then someone's supposed to pay, the employer would not be withholding that Medicare tax, right? On
yes,
the 1099.
I think that's correct. Right.
Would not be withholding that. Would not be withholding anything for unemployment tax. My question then gets to this point. Do we know whether or not the state Supreme Court out of their budget paid either of those taxes to make up the loss of that tax revenue when we switched to a 1099?
I don't have any knowledge of that, but I don't see any way that we would have, that the Supreme Court would have paid that.
When the IRS conducted its audit, and I understood that they issued a check of our taxpayer money to the IRS for $227,541. Was any part of that to make up for the loss to the Medicare Trust Fund for unpaid Medicare taxes?
I didn't see that level of detail in the audit findings, so I can't answer that.
Do we know whether there was any part of that went to pay unemployment taxes that were not paid due to the fact that we shifted from a W-2 to a 1099?
Again, I have no knowledge of that level of detail of their audit findings.
Where would we find, if we wanted to find out how that $227,000 broke out, how that would have been allocated? Who would have that information?
The court's administrative counsel has the audit findings and their detailed audit reports. And those audit reports have their calculations.
Okay. Now, with respect to that same issue, you mentioned someone that was the recusal administrator, clerk, whatever. Do you have a name for that person during the period you've been employed by the court?
I think generally Shannon Green handles the recusals and works with whoever the sitting Chief Justice is at that time to fill vacancies.
does that position shift, or that person that fills that position shift from Chief Justice to Chief Justice, or does that person remain the same?
During my time there, she's remained the same. So I think only if she was on vacation or out for some sort of leave would somebody else take that responsibility. But generally, she's had that responsibility since I've been there.
Okay. Let me shift gears a little bit to this ceiling. I think that's how you say it, the design invoice. And I've got that, I think it's part of Exhibit 63, I believe. $374,139.81, which covered a period from March 3rd of 09 through March 7 of 13, so basically 4 years. Let me give you a minute to look at that, if you would, please.
You say Exhibit 9?
Exhibit 63.
Oh, 63, sorry.
Okay, so I see on there a 4-year period ending with either an invoice date or a service date, I'm not sure which, of 3/7/2013, correct? This is the one that basically refers to Justice's Office's renovations.
Okay, Counsel. Okay, Justice's Office renovations, yes, $374,139.81.
All right. Now, what I'm trying to do is narrow this down somewhat. As I understand it, Justice Lawfrey became a justice in 13. He was elected in 2012 and became a justice in 13. So if I'm looking at this correctly, about the only one on this list that could have been for his office would have been the last one, the $3,000 or $4,050. Is that fair to say?
It is, based on their invoices. But I know, having been in that office when Justice McHugh was there, and then having been in it after the renovations, that Silling would have done a lot of work in there. And $4,050 is not a reasonable amount, just based upon what I personally saw as far as the renovations and the work that went on in there.
Have you come across any other invoices that aren't listed on this sheet that would be after that date from Silling?
The only other ones from Silling after that date indicate work elsewhere. So to me, it looked like maybe the way their billing was done didn't really match up, because everything after that they refer to the clerk's office and the elevator upgrade, and there's just, it seems that something's not quite right with the way their bills, what their bills reference anyway.
Well, let me ask you a different question then about that, because it occurred to me that somewhere along the line we've had testimony that the person that was the Silling decorator went to work for the court sometime around the time that Justice Lawfrey's office was being decorated. Is that consistent with your memory at all? And could that explain maybe that person just was a court employee providing similar services at that time without Silling getting paid for them?
She did come to work for the court. That would be Kim Ellis. She had worked for Silling, and she came to work for the court. I think it was sometime in late 13. It could have been in 14. I can't remember specifically when she was hired. So that could be a question that she could answer. I really can't speak to that.
Okay. Now, that leaves Justices Workman, Benjamin, and Ketchum that would be covered by this period. And I'm looking at the dates of the invoices. It looks like Justice Workman's invoices extend over a period from October 5th of 09 all the way through November 7th of 13, which would pretty well cover this entire time frame of these invoices. Is that fair to say?
I think that's correct, yeah. And I think that Justice Ketchum's office was being done right around the same time as Justice Workman's. I wasn't working there yet, but I think that's kind of what the documents indicate.
It appears from the invoices we were provided that Justice Ketchum's period of renovations went from February 1 of 10 to November 15 of 13. So presumably anything before 2010 would not have been involved in his office. Is that reasonable to conclude?
I think that would be reasonable, with the exception of any kind of, I see on some of these it'll say pre-design or consulting. I don't know how far ahead of that happens in the renovation work. I don't know that.
And finally, it looks like Justice Benjamin's invoice is extended over a period from July 23rd of 2009 to February 28th of 2011, which goes down about almost 2/3 of the way down that list, but anything after that probably was not involved in Justice Benjamin's office. Would that be a fair conclusion?
No, I think that would be a fair conclusion, yes.
And I guess my final question in that area, was anyone auditing these invoices at that time for accuracy? Because it appears that basically 3 offices, $374,000 worth of design services seems awful high for 3 offices.
I believe that each of the ceiling invoices, and I have them here in the binder, but I believe they're all signed off by Steve Canterbury.
We had Justice Davis with like $30,000 on her office. So does it seem, if we just assume these were equally spread among the three justices, $100,000, $125,000 an office seems awful high. Does it seem high to you based on your review of the various invoices in connection with these renovations?
I can't really render an opinion. I didn't see the offices prior to the time that they were renovated to know how much work was done by the architects. So, and it predated my employment there, so I really don't have an opinion one way or the other about it, other than that Steve Canterbury was working there and did sign them. So that's kind of all I can rely on.
But the court has requested more detail where you are in these invoices. Is that correct?
Yes, that's correct.
And no response so far?
No, none so far.
Am I correct that Justice Benjamin's office is now being occupied by Justice Walker? Is that correct?
Yes, that's correct.
And looking at the invoices for Justice Benjamin's office, which basically went through 2011, there was about $30,000 of furnishings. Do you know if any of those furnishings are still in the office, or if not, where they are?
I can't speak to what is still in that office. I know that some items he purchased at the end of his term and took with him. Some items went into storage in our Venable Avenue warehouse, and then some could have been used elsewhere.
And where would the documentation be of the purchase of any of these assets by Justice Benjamin when you left?
There's a cash receipt document. I don't know if I have it documented in here. Let me take a look here. No, I don't have it documented here, but I could provide that. I have a list of all the items that he purchased. There was an appraisal done, and then the money was given back to the state for those items.
Is that the customary process? If someone leaving the court, well, let's say a justice leaving the court would like to take something from their office, that there is an appraisal done, and then the justice is given the option of paying that price and taking the furnishings?
There's no written policy about that, but I was told that that was standard practice, and that was what was done when he left his term.
Right. Thank you. Counsel, do you have any redirect? Where's counsel? No redirect. All right, we'll start back a second round, and hopefully we can, let's try not to ask the same question a third or fourth or fifth time, okay? Delegate Fast.
Thank you, Ms. Troy. Regarding Kenny Bass's FOIA request, if you have a document that could be read in various ways, but the FOIA request simply says, give me all the documents pertaining to the renovations. Now, you thought that this document could be read wrong because it included for Justice Davis approximately $30,000 of silly work that perhaps some of the other documentation didn't include. Is that correct?
My understanding is that Kenny Bass didn't request the documents. He requested, I think, to look at certain documents, and then just a question about if Justice Lawfrey's office cost twice as much as any other.
Was it a written FOIA request?
That I don't know. My understanding was that he was going to submit a written FOIA. That would have gone to our administrative legal counsel. So that wouldn't have come to me. My job was starting to assemble the information so that they could reply to it.
Well, if you were replying, well, were you or were you not replying to a FOIA request?
I was assembling information that I believed was going to be on a FOIA request.
Okay, and if you were going to respond to a FOIA request, then you would have been required by law, would you not, to submit all of the documentation the way it was.
But I think that his question was, did Justice Lawfrey's office cost twice as much as any other? I don't think that he requested any level of detail as far as the other offices go. And no one discussed with me in advance, we're going to hand him this book. You know, I had my binder that I had put together to the best of my ability and make it as accurate as possible. I had sealing in the front of it, and the same thing for the book that I'd made for Judge Johnson. But no one ever said to me, this is going to be publicly released. You know, that was not the plan. The plan was for him to be able to look at it, for me to talk about the book, talk about the production of the book, and then it was just handed to him.
Who asked you to get this ready for submission?
I was not, it wasn't posed to me that way. It was posed to me to calculate the total cost by office, not to make a document that could be released. Just do an accounting of each office so that they could answer his FOIA questions, but never make a document that we can hand out.
But you're not sure if a FOIA request had been submitted at that point? If it had, you didn't know?
No, it would have gone to administrative counsel, and I didn't ask, oh, do you have a FOIA? I just did what I was told to do.
Okay, and so if a FOIA request had been submitted by Kenny Bass, then the duty would have been to present the documents as they were, not taking anything out, not adding anything to it. Present the documents. And if that's the case, isn't that what Justice Lawfrey advised you to do? Leave the documents as they were, period.
I would have to speculate, but that could have been his reasoning behind it. But that's, you know, I can't really say why he said to do it that way. As I said before, I didn't feel like it was incorrect. Her office was still correct. It was just inconsistent.
I understand that. But if a FOIA request had been presented, then the purpose is to present documents, not present explanation. Do you believe that's correct?
I believe that's correct, but the responses were always sent by legal counsel. You know, I would give the documents to legal counsel, and then they would answer the FOIA. I never personally answered any FOIAs.
Thank you. Thank you, Mr. Chairman.
Delegate Zatazalo.
Yeah, just very quickly, and thank you for being here. I want to clear something up for myself. If I read your testimony through the day, it is unclear to me exactly who made calls as far as approving expenses, it sounds like it was a mixture of the court and the administrator. Is that a fair statement?
Generally, it would be the administrative director. When we spoke about the WV-48s, those were always signed by the Chief Justice, and that authorized that person to work as an independent contractor, but then the justices themselves didn't sign the invoices after that. The justices may sign some invoices, but not many.
And did the same thing apply to expenses for renovations and that type of thing, or was it a mixture of people who had control over that?
In the renovation documents, I don't recall seeing any signed by any justice. They're almost all signed by the administrative director.
Okay, very good. Thank you.
Delegate Pushkin.
Thank you, Mr. Chairman. Thank you again, Ms. Troy. We heard in other testimony throughout this from a lot of the folks that worked over there that when Justice Lawfrey became Chief Justice, there were a lot of firings. A lot of people lost their jobs, and there were a lot of people expressed that they were worried about their jobs when they were asked to do things. Now, you expressed earlier that you were not worried about your job, so I'm going to ask you conversely, did you receive a raise under Chief Justice Lawfrey?
Yes, I did. I had been told over the years that I would, at one point that Justice Workman had suggested that I would get a raise, and I didn't. And then I did receive one under Justice Lawfrey, and that was at right around my 5-year anniversary with the court.
It was how much?
$12,000.
Okay, thank you.
Back over on the left side. Delegate Iser, no. Delegate, okay. Perry. All right. Ms. Troy, we thank you for your time today, your patience and your endurance. You are dismissed. Thank you.
Thank you.
We're going to take a minute and ask our counsel to Brian Casto to give us some overview of this 1099 issue because it's a little bit obscure for most of us. Brian, whenever you're ready.
All right, so you've heard a lot today, testimony. You've heard a lot of questions about the terms of WV-48 and 1099.
Is your mic on?
Battery dead. Try getting a little bit closer to your mouth. I'm just going to hit that.
That better? Because I could have just raised my voice. Don't bet on it. I heard whoever said that was that I'm not loud enough. I said don't bet on it. So you've heard an awful lot about the terms WV-48 and 1099 thrown around today, and especially with Ms. Rachel Troy's testimony here. So we're going to give you a little bit of a background on what the pay of senior status judges is. Now, we're going to look at 51-213, which is the first enabling statute. The relevant portion is bolded and highlighted. So all you have to do is look at it. The salary of a circuit court judge is $126,000. I need somebody to advance that. Now, we're going to look at 51910. The text of this section was first enacted in 1949 and twice amended. It has not been altered since 1991, so it has been the law of the state of West Virginia for almost 30 years. It is not to be confused with its preceding section 5199. Many of you may remember 5199 because several years ago there were 2 circuit judges in the state of West Virginia who took their retirement and then ran for re-election. 5199 was amended immediately upon their re-election in 2006 to provide that no judge could both sit the bench and collect his or her retirement money. So 5199 was amended in 2007. 51910, however, has basically been the same for about 30 years. So 51910 provides for the authorization of the use of these senior status judges by the Supreme Court. It allows them to come in and sit the bench when a vacancy is created by recusal, by illness, or other good cause on the Supreme Court or on one of the subordinate circuit courts of the state. And we can see the highlighted language provided is very simple and straightforward. It says, provided the per diem and retirement compensation of a senior judge shall not exceed the salary of a sitting judge. So, if you are a senior status judge and you are placed up on the bench once again and called forth to duty, you can only make $126,000 a year in per diem and retirement compensation. That's it. That's all. That's the cap. It's a hard limit that we believe was put in place essentially for the legislative purpose that if you are doing the work of a circuit judge, you get paid what a circuit judge gets paid. 5199, the preceding section, was amended for the exact same reason. You can't retire and collect your pension and then get paid a salary as a circuit judge. You can't retire, come in as a senior status judge, and be paid more than a circuit judge for doing a circuit judge's job. The 2 statutes are entirely consistent one with another. Now you'll look at the new exhibit which has been placed in front of you, Exhibit 71. The Supreme Court knew this to be the case. If you will look, there is a rule on retired judges admitted to senior status. It is the first 5 or 6 pages that you've been provided, and it was authored by then Chief Justice Tom Miller in 1991. It notes, the compensation for a judge admitted to senior status will be at the rate of $200 per day. And notes in Clause C of that provided, however, the per diem and retirement compensation of a retired judge admitted to senior status shall not exceed the salary of a sitting judge. And if you will look through here, this has been amended numerous times. We have another example of the same rule, which is signed by Justice Neely in his capacity as acting CJ on 15 September 1994, which right above Justice Neely's signature in Clause C notes the same proviso, which is right out of statute. We have updates to this rule promulgated by Justice Miller and by Justice Neely. These updates, we have one from October 1, 2000, signed by Justice Maynard, one in 2006, signed by Justice Davis, one in 2008, signed by Justice Maynard, one in 2010, signed by Justice Davis and attested to by the clerk, and one in 2011, signed by Justice Workman. All of these note that the Supreme Court has increased the per diem rate. Many of these were done with salary increases of the circuit judges, so that the Supreme Court, each time that the circuit judges got a pay raise, would go back in and recalculate the per diem to allow for some increase for these senior status judges to get a little bit more money each time they were called back to the bench to serve. Now, we also have a slightly new wrinkle for you. If you look in your packet, there's a bait stamp WVSCT HJC 00016. Looks like this. It's an administrative order from 2017. This is a document entered as an administrative order of the Supreme Court on May 19th of that year by then Chief Justice Alan Loffrey. As members of the legislative branch, you all may have an opinion about what you're about to read. Justice Loffrey notes in this article that he has general supervisory control as the Supreme Court, and the Chief Justice shall be the administrative head of all the courts. And he recites the authority of 51.910 that reasonable pay be made to such judges who sit as senior status judges on a per diem basis, provided, however, that the per diem and retirement compensation of a senior judge shall not exceed the salary of a sitting judge. And if you will look on this next page, right above his signature, Chief Justice Loffrey says, however, that in light of the administrative authority vested in the Chief Justice, the Chief Justice hereby orders that the Chief Justice has authority to determine in certain exigent circumstances that a senior judicial officer may continue in an appointment beyond the limitations set forth in West Virginia Code 51.910. In other words, they will be paid in excess of the monies due a sitting circuit judge, because the court believes that it is necessary for them to do so. And as Chief Justice of the Court, Justice Loffrey said, we're going to do that. Now, of course, that's a question which would have had to have been litigated, should you have chosen to contest that, before the Supreme Court. We have also, within that same packet, a series of WV-48s so that you can get a better look at what these look like. These have the numbers redacted, which are personally identifying. As you can see, each Chief Justice, starting in about 2012, signed off on these. We have Justice Ketchum in 2012, one from Justice Workman in 2015, one from Justice Benjamin in 2013. We have one, again, from Justice Workman in 2015, one from Justice Davis in 14, another one from Benjamin in 13. These all provide the authority of the Chief Justice to execute the WV-48. Now, why is that significant? Because, as we now know, there is an absolute limit provided in West Virginia Code that a senior status judge cannot make more than a sitting circuit judge. That is the plain language of code. The Supreme Court determined upon, as you have heard from Ms. Troy and Mr. Canterbury, the use of the WV-48 system and the issuance of 1099s as independent contractors to pay these judges in excess of the salary of a sitting circuit judge. You have heard that Justice McHugh, during his time when he was recalled to duty, paid that money back because he knew that to be wrong. What does this mean? Mr. Canterbury also noted that there were personnel who kept track of when the per diem and retirement compensation equaled that of a sitting circuit judge, so that they could then transition that judge over to the WV-48 1099 system and cease using W-2s. This is the mechanism that we have heard used. What's the consequence? This was a scheme whereby they were paid in excess. It is a violation of the requirement, and a senior status judge sitting as a circuit judge would be paid more money than their colleagues who were circuit judges, because they were collecting their retirement and collecting the compensation paid through their regular W-2 and then through the 1099. The managers have discussed this and wanted to bring this to your attention. One of the managers noted that he believed that there was a violation of this particular statute with regard to these payments. And let's look at it. The language that is relevant is highlighted and bolded. This is a very tortuously written piece of legislation. It's an old piece of law, but it has been used in the courts of this state for a long time. It's the provision 61-322 West Virginia Criminal Code on the falsification of accounts. If any officer, clerk, or agent of this state make any entry in any book of account or in any account kept by such state with the intent to enable or assist any person to obtain money to which he was not entitled, such officer, clerk, or agent shall be guilty of a felony and shall, upon conviction, be confined in the penitentiary not less than 1 nor more than 10 years. It can be argued, our managers believe, that causing these accounts to be made in such manner as to pay judges in excess of a sum to which they were legally entitled may place the judges of the court and the officers of the court who cause those entries to be made in violation of this statute. That's what I have, Mr. Chairman.
Questions of counsel? Delegate Lane, followed by Delegate Lovejoy.
Counsel, in looking at this administrative order dated May 19, 2017, where would a normal person find this order?
I don't know that they would have.
I mean, where does it reside?
It's an administrative order of the courts, and I'm not sure, to be honest with you. It's something I've never had any reason or rationale to look for previously.
I mean, is it on their website? Because they have all their decisions and all of that.
But I'm not sure that it is. I've not had an opportunity because literally we received this today.
How did you find this?
How did we find this? We asked for all orders and rules by which the court had governed the issuance of the WV-48s and 1099s to the senior status judges, and this was provided to us as a responsive discovery.
Okay, one more question. What is the statute that talks about retirement making no more than $20,000?
I'm sorry, I can't hear you.
What is the statute that limits if you're getting state retirement, you cannot make more than $20,000 a year without affecting your retirement?
Well, that's a limitation in the PERS enabling statute, which I believe is 51.9, but I'm not sure. Not 51.9, excuse me. 51.9 is jurors. PERS is a different statute. I think that's 51.213, maybe. I'm not sure.
Okay, thank you.
I have that, but I'll have to look at that.
Delegate Lovejoy. Lovejoy.
It's on. Thank you, Mr. Chairman. Counsel, I want to ask a couple questions about the substance of the order. I mean, is it true that our Constitution under Article 8, Section 8, does provide administrative authority to the Chief Justice to assign judges for temporary service?
Yes, sir.
And is it true that under Article 3, Section 17 of the Constitution, there is a requirement that the courts of this state shall stay open and justice shall be administered without sale, denial, or delay?
Yes, sir.
Now, I guess the issue here is the interpretation of this administrative order purports to be that those two constitutional provisions would allow the Chief Justice to fill a judicial vacancy in what I guess the court or the Chief Justice here terms an exigent circumstance?
Yes, sir.
And those exigent circumstances, at least noted by the Chief Justice in this administrative order, I think specifically protracted illness or lengthy suspensions due to ethical violations.
I think that is correct, sir.
When you look at the senior status judges who were allegedly paid in excess of the cap, do they fit in situations where there's alleged to be protracted illness or lengthy suspensions due to ethical violations?
We have an issue at this time, sir, in that we do not have a full list of all the judges who have been paid in excess of the cap.
Okay. And I remember, you know, in my county, there's an issue sometimes where about funding of constitutionally required offices, such as the prosecutor's office, that there are times when acts of the legislature can be challenged, so to speak, by the judiciary under constitutional grounds. And is that what we're seeing here?
I don't think so. I would say to the contrary. We have, if you will recall, this committee during the last session took up a bill which was proposed by the judiciary. It was sponsored, I believe, by the vice chairman of this committee in the House, and was passed to us from the Senate, where it was sponsored by Chairman Trump over there, which was to allow for payments over the cap. So the court last session did attempt to do what, if this were an issue, it probably should have done some sessions ago, which was to bring this issue of these exigent circumstances which were causing some level of discomfort in the judicial process to the legislature's attention, to say to the legislature, this statute is a problem, it needs fixing. But instead, as we have seen, for at least according to Ms. Troy's testimony and that of Mr. Canterbury, for the past decade or so, the court has simply crafted its own workaround without coming back to this body and asking permission to do anything.
And I don't remember, but in the process of whether it was debate or discussion of the bill you just referenced, did anyone from the court come and mention or discuss in any way the practice of this administrative order?
No, sir. There was no testimony from the court at that time, to my recollection, on the issue of how the court was currently satisfying the requirements. The court said it's a problem. We've got people sitting who need paid, but I don't believe, to my recollection, that there was any testimony. I know Mr. Morris, who was at that time the counsel to the administrative director, was present in our committee room upstairs at the time that that bill was moved through our committee, but it's not clear to my recollection, because it wasn't a bill that I handled, whether or not he actually spoke to that bill or not within our committee.
Okay, and I guess what I'm trying to wrestle with, kind of the ultimate end of it, is if we have a statute that the court believes interferes with its constitutional duty to keep the courts of the state open, are they permitted to determine that they can fulfill a constitutional requirement outside of the statute?
I don't believe that they are. I think that they have constitutional mechanisms in place which would allow for a fix to be made, and that constitutional mechanism is to come down here and ask this body to fix it. Now, as to the specific instance, let's be clear. It is not an instance where the judges were not being paid. The judges who were assigned as senior status judges, if they retired through jurors, the judicial retirement system, receive a retirement compensation of 3/4 of the salary of a regular sitting circuit judge. They're paid $90,000 a year from their retirement. They would then have the opportunity to earn up to $36,000 by sitting in the capacity of a senior status judge on assignment. No one is suggesting that the judges are somehow doing this work for free or that they are not being compensated. The question is, to be frank, I think, in my own mind, is are they being paid what they want to be paid?
I understand what you're saying. I guess my question is, in a situation, I mean, the judiciary, unfortunately not too frequently, but often throws out statutes as they believe to be unconstitutional. Do they have to do so in a written decision? And if so, does an administrative order equal, or is that the same as a decision?
I don't think that an administrative order, which can be undertaken sua sponte upon the action of the Chief Justice in his or her capacity as administrative order, which could be rescinded from year to year by the actions of another Chief Justice.
But in the unique circumstance of the issue of providing a judge to decide at a circuit court level, for instance, to keep the courts of the state open, what would be a case in controversy that somehow would get up to the Supreme Court instead of the Chief Justice implementing that constitutional directive?
I think the Supreme Court could have, for example, perhaps, and I'm just speculating. I mean, now you're asking me to put my lawyering hat on and think about how to approach this from a practical matter. If I'm representing the Supreme Court, let's say I'm counsel or assistant counsel or assistant to the administrative director or counsel to the AD, what I'm going to do is I'm going to go in and file for a petition before my own court for a writ of mandamus to compel the appointment of a judge to that position. I'm going to mandamus the court to act, I think. I mean, I think that's one mechanism that could at least get a case before the court, to which parties such as the legislature could then come forward and say, but there's a statute in place. And perhaps we need to, I mean, I can speculate as to 3 or 4 mechanisms like that as to who perhaps would have standing to do so. I think perhaps even the circuit clerk might have standing. The circuit clerk could say cases aren't being heard. Perhaps the circuit clerk can come to the court with a petition for a writ of mandamus. I mean, I can think of 3 or 4 different mechanisms by which that case could be brought before the court and an appeal heard and a decision rendered.
Okay. Thank you.
Delegate Miller, followed by Delegate Overington, and then Delegate Summers.
Thank you, Mr. Chairman. Council, as a normal rule, does anyone that has general supervisory authority over an entity that's given by the Constitution, so most elected officials per se, at basically any level of government, do they have the ability to violate the Constitution or West Virginia Code?
No, sir. Not generally speaking, they would not.
Would that not also apply to the Supreme Court of Appeals?
I think that it would, sir.
Is there any provision in code or in the Constitution that provides for exigent circumstances?
No, sir. Not to my knowledge.
Thank you, Mr. Chairman.
Delegate Overington, followed by Delegate Summers, and then Delegate Fast.
Thank you. Are we aware of any cases where the court was not able to do its duty because of a shortage of qualified judges in senior status?
We have not been made aware of any.
If the legislature is not in session and something like that happens, what would the normal response be for the court?
Well, we know that the court has acted to fill vacancies created by emergency, by the appointment of senior status judges. In some cases, they have detailed judges who were regular sitting judges in other circuits to hear cases. In some cases, they have detailed other justices from within the same circuit to hear cases. So there's a varied array of mechanisms by which they can address that issue.
Thank you. Thank you, Mr. Chairman.
Delegate Summers.
Thank you, Council. I have 2 questions. In order to be in violation of 61-322, do you have to actually have had a signature on a WV-48, or would you just have to have knowledge of the process?
I don't know. I don't know that it would necessarily require a signature, because the language of the actual full statute, which you can see up there, notes the making, altering, or omission. So, I mean, a person who omitted an entry, it wouldn't necessarily require a signature, I don't think, but it would require, I think, because of the fact that it's alteration or omission, some action. I don't think mere knowledge would necessarily do so, but I think it would require an act or omission.
Would it be regarded as an omission if you knew this was occurring and then you did nothing about it?
I don't think so, because the omission is actually the omission of the entry is what is called for.
Okay. And my second question is, in this order that you gave us by Justice Lawfrey, is this because these retired justices have the retirement of, you said, maybe $90,000, and then they can make up to $126,000 per the law, but they're refusing to continue, if it's like they're in the middle of a case, they're refusing to continue unless they make more money?
We are not informed that any of them actually refused to do so. And in the case of Justice McHugh, we have an absolute counterexample of one retired judge in the state who said, I know that this is a problem and I am not going to continue to receive this money. And who we are informed by Ms. Troy's testimony today, turned around and upon his own action, took the affirmative act to write his check back to the Treasurer of West Virginia to indemnify this state for whatever it was paying him in excess.
Okay, thank you.
Delegate Fast.
Thank you. Counsel, what options are there to fill a temporary vacancy in a circuit court position?
Well, as I stated earlier, it depends. The court has in the past, of course, the senior status judge route is the one we're most all familiar with. The court has, if there are multiple judges within the same circuit, sometimes allowed another judge within that same circuit to step into that position and hear those cases and simply divvy up the workload. The court has on occasion taken a judge from a neighboring circuit or a close by circuit and asked that judge to come down 1 or 2 days a week and hear cases from that docket. So the court does have in its capacity as the administrative overseer of the courts a varied number of actions that it can undertake.
What about a vacancy? It's a temporary vacancy, but for 2 years. And there's only one sitting judge in the circuit.
Again, they could have, in that instance, filled it by a series of rotations. They could have placed multiple judges within it to hear certain cases. They could have assigned, as they did in that case, one judge from the senior status to hear those cases.
And we're talking Nicholas County.
Yes, sir. I know the example you're talking about.
If they did assign, which they did assign a senior status judge, that would inevitably put that senior status judge over the sitting judge rate for that length of time.
If they were to pay that senior status judge the per diem every day, yes, it would.
And of course, in any given circuit, you're going to have prolonged and ongoing cases, abuse and neglect cases, criminal trials that a judge makes rulings on pretrial motions, and then having the jury trial, civil trials, the same thing. So if you have judges just coming and going on different days of the week and not the same judge, then you could get a hodgepodge of justice without having the same judge presiding long term.
I think that's been represented, but I also think that it could be that you could simply assign a judge to hear certain cases. You could say, Judge X, you're getting cases, civil cases 001 through 008. Judge Y, you're getting criminal cases 001 through 009. Judge A, you're getting criminal cases 0010 through 0015. And let those judges set that up for hearing on those various dates. I think there are mechanisms by which multiple senior status judges could have been assigned to fill that gap. That's a mechanism that could have been used. Alternatively, they could have simply, the senior status judge in that case could say, I understand that I'm essentially being recalled to active duty, as it were, and written those payments back, as Judge McHugh did when he sat over here on the third floor for 2 years, filling that vacancy on the Supreme Court. So there are a couple of different ways it could have been done, but they chose to go with what I think in their minds was the easiest route, to appoint the judge and to use the mechanism which they had been using for some time to continue paying the per diem in excess of the statutory limit.
Do you believe that this administrative order we're looking at is a result of the Nicholas County situation, since it was a rare 2-year temporary vacancy?
To be frank, I'm not sure. Yes, that's certainly an argument. It could be an argument that Justice Lawfrey knew of the issues that were accruing with regard to this potential violation of statutory law and attempted to fashion a credible rationale by which an underpinning could have been provided to allow it to continue. I mean, I can't speculate as to what his intentions were because I've never had a conversation with him about what his intentions were.
Thank you. Delegate Holland, followed by Delegate Foster.
Thank you, Mr. Chairman. Council, a few different questions. In the testimony that we were hearing today, it was being referred to as the $20,000 limit. Now, we have two different scenarios that judges can fit under, the PERS and JRS, is that correct?
Yes, sir.
And the PERS limitation is the $20,000.
Yes, sir.
And those are the ones that don't qualify under the JRS retirement.
That's correct. Okay. Or have elected to participate in PERS instead of JRS.
Yes, okay. And it seems that this past legislative session that they tried to fix the wrong by getting some legislation passed under for 5910, is that correct?
I think that would be a fair statement, sir.
And if it was such an emergency, and they deemed it an emergency that the administrative order was written by Justice Lawfrey, wouldn't another remedy to that is they could have approached the governor to call a special session and bring this 5910 up to fix if it was that big of an emergency and do it correctly?
Yes, sir, they certainly could have.
And there was no attempt to do that that we know of?
Not to my knowledge, sir.
Okay. And the last question on the 61322, the delegate raised a question about if there was no hands-on, just knowledge, that they could not be held under 61322. But could they not be held under 611031, conspiracy to defraud?
Well, that is certainly a possibility, I suppose. I mean, the gentleman has probably brought more charges against people for that crime than I ever have, and probably knows that statute a little better than I do.
Okay. No further questions. Thank you.
Delegate Foster.
My question is on the, because basically they're paying, if I got the numbers correct, they're being paid $90,000. They can be paid up to, what was it, 126?
Yes, sir. That would be for those under the judicial retirement system.
Okay.
Those under PERS would have whatever their retirement was, which we don't know what that could be.
And my question is, in filling these vacancies, to me it seems like the easiest route would be, well, basically you can receive $36,000 to equal the salary of a sitting judge. So you're doing the job of a sitting judge at that point. Why wasn't that just the cap? And
you have now articulated what I think was the legislature's intent when it passed that bill in 1991. And I think why it is essentially consistent with the act right next to it, 5199. Both of them state that essentially that a retired judge is going to collect the money of a retired judge, or if they are sitting on the bench, the money of a sitting circuit judge, and those are your two options. I think that's exactly, you've articulated what I think the legislature's intent in 1991 probably was.
And we have no information to say that any judge said, well, if that's all I'm getting, I'm not going to sit.
We do not at this time, sir.
All right, thank you.
Delegate Pushkin, followed by Delegate Eisner.
Thank you, Mr. Chairman. You stated that there was a bill that passed through the House last session.
Yes, sir. It passed through the Senate and passed through our committee. It did not pass the House.
It passed through our committee.
Yes, sir.
But was it passed by the House?
It did not pass the House.
Okay.
It was one of those that died in the last week of session, as many bills do. I don't know what happened to it.
Was it moved to the House calendar? Or?
I think that's the case, but I'm not sure what the issue was.
Okay. Well, I'm asking now. In the past, there was a legislative liaison between the court and the legislature.
Yes.
Was there one last session?
I don't think they had. I think they had terminated their then legislative liaison, and I think most of the contacts that our committee had were through Mr. Morris.
Was through where?
We're through Mr. Morris, Mr. Chris Morris, the assistant to Judge Johnson, the administrative director.
Okay. And so when Chief Justice Lawfrey at the time fired the legislative liaison?
I believe he had, sir. I believe that's
and the bill didn't pass. All right. Thank you.
Delegate Eisner, followed by Delegate Lane.
Thank you, Mr. Chairman. Council, I just want to follow up on a couple of things. There's been some discussion of Nicholas County creating a situation, but that's not it, right? You have Upshur County, where there was a long delay by the executive branch in making an appointment to fill a seat. Is that correct?
I assume that the gentleman is correct. The gentleman knows that circuit far better than I do.
Okay. And I'm just looking at some of the judges that are referenced in the material we have. I think it was Judge Henning that filled that for a very long time. Are you aware of a similar situation that I think occurred up in Hardy County, where there was a long delay by the executive in making an appointment?
I actually am aware of that because I had a case in front of Judge Cookman many years ago, around the time that I think that he left the bench, and that occurred.
Judge Cadle spent an awful lot of time there filling that one.
I think that's the case, sir, yes.
And then Judge Cadle and Judge Steptoe back in my home county of Randolph spent really long length of time there filling in for a judge that was suspended, during some ethical investigations. Is that correct?
Yes, sir. I believe that is the case.
So this goes well beyond, what went on in Nicholas County as far as some of these judges go.
Oh, yes, sir. And I mean, we've had a case just here in Kanawha County with Judge Stuckey's illness, in which there was a rather long appointment there. I mean, there have been long appointments in many of the circuits. Due to illness or, as you put it, misconduct or other reasons why a particular seat had been vacated.
So, following up a little bit on Delegate Lovejoy asking about how this issue might be addressed, you indicated perhaps the circuit clerk, could file a writ, or, we're talking about who might have standing to get a judicial vacancy filled, correct?
Yes, sir.
So, isn't the reverse also true? I mean, would the auditor or some other branch have, or some other state official have standing to, challenge Chief Justice Lawfrey's 2017 administrative order and say that, it violates statute?
I think your construction is eminently logical, that it is possible that the auditor and the treasurer in their capacity as the overseers of disbursements of funds may have had the standing to do so, absolutely.
So the statute that we've been dealing with, I think it was 61-322, was last amended in 1991?
Well, 61-322 has not been amended for some time. I do not know the last date on that. The one you're talking about with regard to the limitations, 51-910, was the last amended in 1991.
So that's last amended in 1991. Then Chief Justice Lawfrey issues an administrative order in 2017, which effectively conflicts with the statute to some degree, correct?
Yes, sir.
Okay. So until somebody challenges Chief Justice Lawfrey's administrative order, wouldn't that be the prevailing law?
Well, actually, I think the prevailing law would be what the statute would be. I think there's the question as to whether, and I think this is the question that the gentleman from Cabell asked, what is the prevailing law? Is the prevailing law the administrative order undertaken by the court, or is it the statute? And until we have resolution of that in some form or fashion, we have basically, the court has legitimized the process that it was undertaking for the past, according to the testimony that we have had, for at least the past 6 years. But it has only legitimized it on a post hoc basis from 2017 forward. There's no administrative authority prior to that for the practice of the issuance of payment to these judges in excess of the cap via the WV 48 to 99 mechanism that we've heard described.
Well then, I mean, isn't the Supreme Court the ultimate arbiter of, what happens when a statute is in, conflict with the Constitution?
Well, I would say that the process that you are involved in right now probably has restored a little bit of that momentum in your direction, sir.
Well, that was my next question. Is that our role to decide, the conflict between the statute and the potential constitutional obligation of the government to keep the courts open?
Well, you all passed the statute, And you all are going to have to make that determination. That's all above my pay grade.
Thank you, counsel. Just asking for your interpretation. No other questions.
Delegate Lane.
Counsel, if there's a vacancy or a need for a replacement in one of the circuits, could one of the Supreme Court justices sit in on circuit court proceeding?
My understanding is that they can.
They can? Okay. And this administrative order, do we have any knowledge as to whether or not the other justices knew about this order?
We have no information based at this time to say that they did or did not.
Okay, thank you.
Counsel, just a question from the chair. We have November 15th, 91 rule, I guess that's their policy set by the Supreme Court, signed by Justice Miller at that time, that recognized the statute and made no exceptions. Is that fair to say?
That's true, sir. We also had the one from Justice Neely from 1994 that does the same.
I'm getting to that.
Okay.
And Justice Miller was generally thought to be a very intelligent justice during the time he served. Would you agree with that?
Yes, sir.
And then we have Justice Neely, who basically in 94 reenacted the same policy and again basically provided that the per diem and retirement compensation of a retired judge admitted to senior status shall not exceed the salary of a sitting judge. Same language, basically, and no exceptions.
Absolutely, sir.
And Justice Neely was also recognized during the time he served as a scholar of the law and the Constitution. Is that fair to say?
I think that is very fair to say, sir.
And that's been the policy, although the per diem rate has remained or has been adjusted upward since 1994. But until Justice Lawfrey's attempt to override the statute, that policy has remained in effect unchanged. Is that fair to say?
Yes, sir, through many iterations. With
regard to the limit of the sitting judge's salary, setting the limit of the amount that the person, the retired or the senior status judge can receive. Fair enough?
Yes, sir.
Okay, so even if it's not a violation of the policy or of the statute, the court has consistently violated its own policy, has it not? Until Justice Lawfrey attempted to change that.
I would have to agree. They have violated their unwritten directive.
Thank you. Other questions for counsel? Other questions for counsel? Delegate Fleischauer.
Thank you, Mr. Chairman. Thank you. Actually, I have a request to make. I believe there might be alternative interpretations of the statute, and I was wondering if I could ask our minority counsel if he would share possible other interpretations of these two statutes.
Certainly. Counsel, would you yield the podium to minority counsel, please?
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. So let's start with 51.910. Do you think there could be an alternate interpretation other than that explained by our Judiciary counsel?
My reading of the statute, if I could just kind of go through it.
Yes.
I think that's a reflection.
And I think you're going to have to speak into the microphone because we can't hear you. Or adjust the mic, perhaps.
All right, thank you. There are two provisos in this section of the code. And as the general statutory construction rules, provisos are exceptions or limitations to the prior statements. It's the prior statement, it's the singular statement. So the first sentence, the court is authorized to empower to create a panel of senior judges to utilize the talent expertise of former circuit judges and Supreme Court justices of this state. And in the second sentence, the Supreme Court of Appeals shall promulgate rules for said judges and judges to be assigned duties as needed and as feasible toward the objective of reducing caseloads and provided speedier trials to litigants through the state. So the two provisos are exceptions to or limitations upon the rules promulgated by the court. So the first proviso says the reasonable payments shall be made to said judges and justices on a per diem basis. That would be a requirement of the rule. And the second proviso, that the per diem and retirement compensation of a senior judge shall not exceed the salary of a sitting judge. It's my practice in writing legislation over the years, and if you're going to prohibit an activity, you need to expressly set it out. You can't prohibit it by inference. The fact that the second proviso only prohibits the per diem and retirement compensation shall not exceed a salary of sitting judge, it does not expressly, and I mean expressly, prohibit any other compensation to that judge. I know you think I might be parsing out, picking details on this, but I would tell you that whenever a criminal law is going to be applied, like there's attempting to be here, 61.322, I think you have the responsibility to have express prohibition in the law. And I don't think that is an express prohibition. I think that my thinking as the court, when they were looking at this, read this is the max we can do. If you're going to pay per diem, you cannot pay him per diem beyond the combination of the salary of the pension of the judge and the per diem rate to meet a salary of the existing judge. That's your prohibition. Now, if you want to go out, and I think what the court has done is through their general authorities to regulate the practice of the court, they've created an exception outside of these rules to allow payment on a contract basis for people they have designated through their authority in the first sentence to designate as senior judges. So if they've written a letter designating somebody as a senior judge, they are authorized to act as a judge regardless of whether they're paid or not. That's the authority to act. The second part is this. I'm only saying to the extent that you're trying to apply 61.322 to this provision as a violation, I don't think it fits. And that's my analysis of this section.
Do you want to follow up on that, Delegate Fleischer? Questions?
Yes. So let me just rephrase it. So what you're saying is, I think, is that this does not exclude, this does not prohibit payment on a contract basis.
It doesn't authorize it. It says the only prohibition in that sentence is that the per diem and retirement compensation of a senior judge shall not exceed the salary of a sitting judge. That's the prohibition.
Okay. What are you saying? It doesn't authorize?
It doesn't authorize them to pay by contract work. It doesn't say you can, but it doesn't say you can't. Okay. And my point being, if you're going to place a criminal penalty on somebody for a criminal act, it needs to be expressed in the code what the criminal act is. It can't be done by implication or by some kind of conclusion that the public policy was that no retired senior status judge can make more than a sitting judge. I mean, that might have been the prevailing idea here, but it's not expressly said anywhere in that article that I could find that that's prohibited. It's just through this implication that it's not allowed.
Okay, so you're saying that there is a possible way to interpret this to, it's not disallowed by this statute.
I'm just saying I don't think it's real clear, and I think that there's clearly a prohibition that you cannot make more with your per diem and your retirement compensation than a sitting judge, but there's no prohibition for making more than that in some other fashion.
So you don't think it would be fair or consistent with our application of the criminal laws to say that it's a felony?
Well, yes, that's what I think.
Is that?
I think that that statute does not rise to the level of being able to assert a felony against a justice for violating that provision and using 61.322 as your penalty.
Thank you.
Are there questions of counsel regarding his interpretation of the statute? Gentleman, Delegate Foster, followed by Delegate Summers.
My question's on when you were talking about the per diem and the salary not excluding, and you said that just because it's a contractual services that it wouldn't exceed because it's outside of per diem and salary?
The sentence says the per diem and retirement compensation of a senior judge shall not exceed, in combination, shall not exceed that of a sitting judge.
And that's the thing is, but these contractual services are paid per diem, correct?
Well, my understanding of how it works is they've been paying people per diem up to to the salary level, and then they've quit paying their per diem because of this prohibition, and then began paying contract, which is a different contractual relationship than it is on a per diem basis.
But in the documents we saw, it's still $435 a day, which was per diem.
I know it's legal sophistry. I'm not disputing that. I'm just saying that for purposes of applying a criminal code to these folks, I would like a little more clear expression that there's actually a violation in existence here other than that proviso.
And that's my question. How would you clarify that? Do you want to say
if I would write in the statute, I would say that the per diem retirement and allowances, let me say, the reasonable payment shall be made to said judges and justices only on a per diem basis. That would do it.
Because otherwise, I mean, if for it to clarify, I would have had to say per diem or contractual or bonuses or...
Well, and I would, my take on it was they understood they were dancing around this language, and they had a serious problem they were trying to address. They said there was an express prohibition for doing this, so they did it. They said, right or wrong, that's your all's judgment. You're all the legislators here. I'm just doing what I do, is reading the statutes and making an assessment on what I think the implication of it is.
But either way, the payment was made per diem.
Yeah. Well, it wasn't a per diem. They entered into a different relationship. It was the per diem was capped, and they started paying on what we call a contract basis, which was like an independent contractor, so to speak.
All right. Thank you.
Delegate Summers.
Thank you, Counsel. I had one question. Why, on this interpretation, do you think the IRS said you can't do that?
I think because of the implications on their pension plans. Whenever you you earn too much money doing the job you did prior to your retirement, there are limitations. Like we as legislative employees, I'm a part-time person. I could work so many days a year and still draw a pension. And I think they were trying to protect their efficacy of their pension plan, because if you exceed those rates, you can be required to reimburse some of your pension to the state. And so if I exceeded the amount of work I'm allowed to make by law, I wouldn't go to jail. I'd be required to pay back some of my pension.
So should we disregard the IRS's recommendation based on that one statute?
I haven't seen their recommendation on what their objection was. Now, I'm not speaking towards federal law. This could be something totally different. This is only analysis of that statute and in the relationship that to the criminal provisions we're talking about.
Further questions of counsel? Delegate Miller.
Thank you, Mr. Chairman. This might be geared more toward Mr. Casto.
Well, let's finish with our current victim, and we'll move to another victim in a minute. Okay. Are there any other questions? I have a question. I want to be sure I understand the distinction you're making. You're not saying that this activity doesn't violate their own policy. You're just saying it shouldn't be, based on the statute, the basis for a criminal charge. Am I fair? Is that fair?
I think that's very fair. I haven't done any research on that, and I would be wading in this deep water if I offered an opinion on that.
So you haven't had a chance to look at the various exhibits from
I have. And I would say, my first observation is all these policies related to their per diem reimbursements as authorized under the statute and directed by the statute. Now, whether the court had authority outside of those per diem payments through their own rights as a judiciary to administer the courts, and if they were lawful in that capacity, I don't have an opinion on that.
You would agree that the rate that they are paying under this contract is exactly the rate they authorize as per diem under their policy?
Well, it's certainly probably more than a coincidence.
It's the last policy update was $435 a day, which is what they are paying under this WC 48.
Yes, but I think this was done in their effort to try to comply with the statute and still keep their judges in the courtroom.
So there's good intentions for disregarding the statute.
Well, I'm just not convinced the statute has been disregarded.
I understand your interpretation. Okay.
Thank you.
Any other questions for our friend over here who's taking our grilling with good nature? Okay, Counsel, Delegate Miller, further questions of counsel? Our staff counsel, yes, go ahead.
Thank you, Mr. Chairman. And I'm trying to wrap my head around 61.322.
Yes, sir.
as it applies to what we're discussing if we're trying to, in effect, prepare a criminal case.
Yes, sir.
Is there any question that anyone at the court is falsifying accounts? At least on its appearance, everything is clear that there has been a contract signed. There's no excessive payments. It's per whatever their schedule is. You see where I'm going with that? Is there any fraudulent activity in regard to the numbers, I guess you'd say?
There's no fraudulent activity with regard to the numbers, but the statute, even though it's captioned as falsification of accounts, provides that it's simply if you are doing anything which enables someone to obtain monies to which they are not entitled. And so I would argue that there is a possibility of construction based upon our manager's representations that these persons are thus, because of the hard cap, not entitled to those monies. And that if you make any entry which enables persons to obtain money to which they are not entitled, you have violated the provisions of the statute, even though there is no falsification. The caption of the statute just is what it is.
Understand, and my normal thought process is to play devil's advocate by the time you get to the end of a case. So my ultimate question would be, is there, as what's normally present in a criminal case, do we find criminal intent involved in this?
Well, there is a question of intent, and I don't know that it's criminal intent, but it doesn't say that the intent had to be criminal. It simply says the intent is to enable the person to obtain money to which they were not entitled. So the question of whether or not the court's actions constituted an attempt by the court to allow a person to obtain money to which they were not entitled would ultimately be a question for the trier of fact.
Thank you. Thank you, Mr. Chairman.
Mr. Chairman, if I may.
Counsel, you want to proceed? Go ahead.
I have a clarifying comment upon my co-counsel's point. I think he would be correct if the court had not understood that what they were doing was continuing to pay per diem. I'd like to call your attention to Exhibit 65. You've all been handed this out previously. This is a contractual payment made to Judge Cadle when he was sitting by special assignment in the year 2013. You will look, the fourth page of that exhibit is the signed WV-48, which was executed by Judge Cadle and Justice Benjamin in 2013. We have two of the inner pages which appear to be for dates when Judge Cadle was sitting in Moorfield in May and June of that year. And on the front, on this page of Exhibit 65, I want to point this out to the committee. It says on the comments line, about 3/4 of the way down the page where I indicated, it says this is a senior status judge per diem. The court did not change the captioning on what it was paying these individuals when they were being paid under a West Virginia 48 or whether they were being paid under a W-2. The court viewed it as a per diem payment to a senior status judge, and the court knew, as we have heard, from their own policies that per diem payments, when combined with retirement, were to be capped at the compensation of a sitting circuit judge. That's what we have, Mr. Chairman.
Other questions? Other questions of counsel? Yes, Delegate Fluharty. Counsel?
The criminal code provision you cited earlier, well, that's a specific intent crime, isn't it?
It is an intent crime, and the intent is to enable a person to obtain money to which they were not entitled.
So a simple entry would not constitute a crime?
No, sir. It would have to be the persons who would have had knowledge that the persons were not entitled to that money.
So to prove that up, you're going to have to prove that justices had knowledge and intended for more money to be made available to sitting judges.
Well, I think that would be, if someone were to try to prove that, I think that would be what they would have to prove. If the Kanawha County prosecutor, for example, were to look at this and believe that that were actionable, they would have to prove that the judges knew or should have known that these persons were not entitled to that money and that they undertook action specifically to get them that money despite their knowledge of the law. And that would be the bar.
Thank you.
Other questions? Delegate Flashhour.
Thank you, Mr. Chairman. I guess just to follow up on that, this Exhibit 66, this is something that someone entered into a computer. This isn't something that one of the justices entered into a computer.
No, it's within the FIM system originating from the Supreme Court. To say in what manner this was transmitted or what it was intended to be, but you'll note that the electronic authorization is from Ms. Troy, the director of financial management at the court at the time. So this is whatever, I cannot speculate as to who the original preparer of this was, whether that was her or some other person at the court, but it appears to be something that the auditor's office would have received from the court.
Well, I guess what I'm saying is if they change the status to contract status, this document does not prove that they were doing it under the statute. This document, because it's just a computer entry.
Well, I think all that we have in proof of this is that it's still being captioned as per diem, that for whatever reason that was what, we have to take it for what it is, and it says that it is a payment of a senior status judge per diem for periods within August 2013. And that's all that I can go on is what I see before me.
Right, but I don't think this is like proof that the justices knew that they were, I just don't see it that way. Okay, thank you.
Delegate Summers, followed by Delegate Eisner.
Thank you, Counsel. Can you help me understand? I'm not following this. Why are you filling out a WV-48 if you haven't already met your amount? So why would they sign that?
They would not fill out a WV-48 unless they had already hit that point. That's exactly correct.
Okay, that's what I thought.
We heard testimony from Mr. Canterbury that they had a person assigned to facilitate the transmission and completion of a WV-48 on the period after that cap had been hit.
Yeah, that's what I thought. Thanks.
Delegate Eisner.
Thank you, Mr. Chairman. Counsel, could you turn your attention back to Exhibit 65?
Sure.
This document, where did we obtain this from? Was this from the Supreme Court?
This was obtained from the Supreme Court.
Okay. Because about the third line down at the top says it's from the Financial Information Management System of the Office of the State Auditor. Is that
yes, sir.
Correct?
That's what it says.
So was this generated by someone in the Supreme Court or generated by somebody at the State Auditor's office?
The person who would have had better knowledge of that was here today earlier, sir. Okay,
fair enough. Do you know if there was ever a copy of this that was ultimately signed by the State Auditor or somebody, their designee?
We do not have any knowledge of that at this time. We received this document today.
There is a line at the bottom that appears to be a signature line from somebody from the State Auditor's office, though. Is that correct?
Yes, sir.
So if somebody from the State Auditor's office was actually the one that prepared this and or ultimately signed it, is it your position that they would have violated 61-322?
I'm not the one to say whether or not that law was violated. That's a jury question, and that would have to have a prosecution initiated to determine whether or not there was even chargeable evidence on that. I'm not speculating as to whether or not that law has been violated in any way, shape, or form. I know that one of our managers raised that it was a potential violation, and I believe that there was a potential that that law had been violated, and so I'm merely bringing it to the committee's attention.
Okay. Thank you, Counsel.
Delegate Miller.
Thank you, Mr. Chairman. Counsel, are we aware if any other judicial appointments are made this way for senior status or a fill-in position, such as magistrates or family courts in the state of West Virginia?
I'll be entirely honest with you. I have in the course of my career never had occasion to question how magistrate vacancies or family court vacancies have been filled. I've never been in a trial before a magistrate or before a family court judge who had a successor sitting or substitute sitting by designation. So I have no idea how those vacancies are filled.
If there was a need for a substitute family court judge or a magistrate, on its face, would this administrative order signed by Justice Lawfrey apply to those positions as well?
I don't believe so, because I think he speaks specifically to the judicial statute in 51.910. And I think what he is speaking solely to, the way that I read that order, is the position of judge, not the subordinate court positions such as family court judge or magistrate.
Okay, thank you. Thank you, Mr. Chairman.
Further questions of counsel? Thank you, counsel.
Thanks, sir.
We have some additional exhibits that we want to share with you that have just come in recently, and I'm going to ask our Chief of Staff to explain what they are, and then we'll pass them out. No more testimony. Marsha Kaufman.
Is she going to explain the exhibit?
Yes. I forgot. You can stand up if you wish.
Maybe you should sit down.
I won't get up if I sit down. Counsel, go ahead.
Thank you, Mr. Chairman. The exhibits that have just been passed out to the committee are labeled as Exhibit number 70 and Exhibit number 72. We do not have any witnesses to testify as to either one of these documents. They are being provided to the committee for informational purposes. If follow-up is needed later, we can certainly do so with witnesses. Again, these are being provided for informational purposes, as some of these issues have been brought before the committee during the recent hearings. Exhibit 70 is a letter dated July 26, 2018, from the state auditor to the West Virginia Supreme Court of Appeals. This letter references purchases of meals by the Supreme Court. It is a 3-page letter. I will note, and you have not been provided copies of these, this letter does reference I believe it is 4 advisory opinions from the Ethics Commission. If anyone would like copies of those, we will be happy to make copies of those advisory opinions. They also address meal purchases in different manners or in different instances. So those can be provided. Again, this is Exhibit 70, again, just the letter from the State Auditor. On page 2, and certainly the committee will have the opportunity to read the entire letter, I will just note on page 2, above the Supreme Court policy and defining allowable expenses, above that, the position of the auditor is noted that public employees and public officials, including specifically members and employees of the Supreme Court, may not use public funds to purchase personal meals during a non-travel workday, and further states that an expenditure of public funds for a personal meal will neither be processed nor approved by the State Auditor's Office. Again, this was received via FOIA request, so this is being provided to the committee for informational purposes. Exhibit number 72 that has also been provided to the committee is information regarding a payment that was made to Ms. Allen in 2017 for writing or drafting rather an opinion in the Quicken Loans case. This, I believe, has been mentioned at some point throughout the course of the proceedings. So this information is being provided again for the committee to consider. The exhibit should contain 2 pages, which are the bill that Ms. Allen submitted. It notes on page 2 of this that there was an agreed upon cap that she was entitled to $10,000 for her work. Her total charges were actually $14,950, but the cap kept that at $10,000. The last page of this is an email from what appears to be an administrative assistant for Justice Walker to the former administrative director, Judge Johnson, discussing this invoice and having the invoice paid. I will note that I believe there was some testimony, and just to clear up any confusion, it is our understanding that Ms. Allen was actually paid to write 2 separate opinions. This deals with an opinion that was written in 2017. It is our understanding there was a prior opinion drafted by Ms. Allen in 2016. That was in a case in which all of the justices, as I recall, I believe all of the justices had recused themselves. So that information is not provided in this. This one was different in that regard. I don't know if there were any recusals. But the prior one in 2016, I believe all justices had recused themselves, and it's my understanding that that was also a $10,000 payment. Mr. Chairman.
Thank you, Counsel. And understanding that neither of these exhibits were prepared by the committee staff, are there questions that might be answerable? But basically, we're just disseminating information we've received pursuant to either a FOIA request or unsolicited information, I think it's fair to say. Are there questions? Yes, Delegate Sabonia.
The email that was sent from Gary Johnson to Whitney Humphrey about the payment to Ms. Allen, it says in the email that Justice Walker wasn't sure if she was still an approved vendor or if a formal contract is necessary. And in this email, they're stating that they received the invoice from Ms. Allen. Is it common practice to contract out for $10,000 of work without knowing if someone's an approved vendor and without a formal contract? Doesn't that seem a little backwards?
I can't speak to that. I'm not sure what the court's process was in that regard. I believe, and this would be speculation on my part, when it references in that email, wasn't sure if she was still an approved vendor or if a formal contract is necessary. I am not sure if that references her earlier work in 2016, because she also did work for the court in 2016. So that, again, pure guess on my part, but it may reference the earlier work done.
And when did Ms. Allen start her employment with the court?
her current employment with the court. I'm not sure, it would have been after Judge Johnson, the former administrative director, left this past summer, or this summer. I believe he left in June, if I recall correctly.
Thank you.
Other questions of council? Other questions? If not, as was announced previously, we're going to seek to adjourn into executive session. This whole process was subject to an exception under the Open Meetings Act, but we've elected to try to keep as much of it in open session as possible. However, there are a couple of issues that I think are appropriate to discuss in executive session. The intention will be to go into executive session. We do have dinner for all of you. When we're finished with the executive session and reconvene in regular session in the committee room, the only purpose of that will be to adjourn until tomorrow morning. So there won't be any action taken, won't be any votes after we come out of executive session. So that's for the benefit of the press. If you want to stick around, fine, but we don't anticipate any action taking place, and we will resume tomorrow morning. Recognize, yes. We don't have to, but we need to set a time for executive session. Now let's just do it.
Mr. Chairman, under the authority of West Virginia Code 6-9A-4B2A, I move that the committee reconvene upstairs in executive session at 5:20 p.m.
You've heard our Vice Chairman's motion. Is there any discussion? If not, all in favor will say aye. Aye. Opposed will say no. The ayes appear to have it. The ayes do have it. We'll be in executive session upstairs at 5:20.
You're required to